I may be permitted to move an unlisted motion, my lord.
Today,
My lord.
you have to bring it before 1 o'clock.
My lord. Obvious.
With the consent of others, I make it, I cannot tell Lordship. Part hard matter, Lordship. In the documents that given their last hearing, Lordship has asked us to produce some documents regarding the historical documents as provided under the procurement act, Lordship.
Which one is this?
I cannot tell, Lordship. So we will file our affidavit today, additional affidavit, Lordship.
Matter pertains to what?
Lordship, whether the petitioner has submitted MSME certificate.
Oh, yes.
That matter. Oh, well,
File affidavit today, Lordship.
It's parted.
part on my lord.
Document speak the matter at today.
Item 10.
Yes, sir.
It was for disposal, my lord. There is a stay, my lord, going on.
There is no stay.
My
My
lord,
lord, even without a stay, my lord, the LOA has not been awarded to me, though I am the lowest bidder.
Most of
There is an interim order that, not, it will be subject to, yes.
It will be subject to.
We'll take it up.
Lordship, outstation considers some personal difficulties. Lordship, Lordship may have any day.
Short adjournment may be given, my lord, in that case. Short adjournment may be given, my lord.
No, short.
No.
Very short.
We have already filed our affidavits, my lord.
When do you want?
The
Short means when do you want?
next week, my lord. First week of February,
You should
28, my lord.
request- You should request the Chief Justice to have less holidays.
Has already been reduced, my lord. Now,
We already have settled.
first
my
and
lord.
third, now we have a working days.
The first and third is okay, but then also 23rd, 24th, 25th, 26th.
4 days.
Closed.
Oh, then stay, na.
Stay. 28, my lord.
28, my lord.
28th is a Wednesday, na?
Tuesday. Oh, sorry, my lord. Wednesday.
It would be difficult. don't you
29th,
think?
my lord.
Otherwise, it's a bench tree, is a
My lord.
more taxing bench.
Yes, yes. 29th, my lord. 29th.
Right. At 2 p.m.
My lord.
At the request of Mr. K. Kulta, the learned counsel appearing on behalf of the petitioner, matter adjourned to 29/1/2025-26 at 2 p.m.
My lord.
Interim orders passed earlier shall continue till then.
My lord.
There was no interim
No
order.
interim
no
order.
interim order.
No interim order.
But then,
It was only subject to my lord.
Subject to, we are also not able to give,
what is there? There's no interim orders.
because we are also not give the LOA to them, my lord, because of the
Do you
pendency.
think that your case is weak? Mr. Gupta, your case is weak?
No, my lord.
Then, why you're not
No.
awarding it to him?
My lord.
No, no.
Anyways, 29th at 2
No.
p.m.
My lord, I may be allowed to move one, my lord, unlisted motion today, my lord. Matter relates to selection and appointment of radiology technician in health department, my lord.
Why not on Monday, Tuesday?
Then on 27th, my lord, 27th.
27.
27.
Huh?
Yesterday, the matter was listed, but left over your lordship. Appeared for listing.
Motion.
Not admission matter, but.
You didn't get your date fixed yesterday. You should have got your date.
Not the long date, there is urgency there. I also filed IA, but matter will be infectious because selection and appointment matter is
Okay.
27 or 28 years. I also filed an IA, it was mentioned on this case.
28 for what?
Admission is because otherwise, I have also filed an IA for interim order here, because otherwise matter will be infectious.
29th. Okay. 28.
Please, Your Lordship, I beg to mention listing of a matter, my lord, in the admission column, subject to your lordship's convenience, any day and a miscellaneous day, my lord. The respondents are yet to file their affidavit pertains to redesignation of posts held by the petitioners in Guwahati Medical College. Non-medical posts, my lord. The subject, your lordship.
Okay, February 9th.
9th of February. I'm grateful, my lord.
May I recommend listing matter two admission matter, madam. February 2nd.
11th.
Yes, obliged.
Regarding permission for listing the matter, one is lordship 29 lordship, another two is lordship 9 and 11 lordship.
What?
He mentioned my lordship.
For what?
29 is a contempt petition lordship. for permission listing. Lordship.
Why? What is the urgency? We'll have it on.
Urgency is Lordship, due to non-release of the VRS benefit. Lordship.
Have it on 11.
Lordship, I beg to mention for listing of one WPC. Matter,
A motion,
Lordship order.
orders. 16th.
Make this lordship, I want to mention regarding listing of the deed for admission lordship. Next week lordship, lordship family pension.
Why?
Because in this matter lordship, respondents have not filed their affidavit yet, and the petitioner is unmarried daughter lordship. And
Unmarried daughter.
yes, lordship. So,
What is the matter pertains to?
family pension.
Family pension. Okay, 20, 30.
I would like to mention an item for listing of orders of a content matter.
Contempt. Chalo, 16th February.
16 February,
February.
first, second, next week of
Next week, not possible. Ask the Chief Justice to reopen the court on 26th. Then we can. 16th February.
Maybe. But one case was filed earlier, that was already in the already agitated.
Oh, this matter.
Yes, that matter when I made a subsequent prayer with regard to regulation, where initial prayer was for by the minimum wages for vendors. But you know what happened after this case was filed, now it's the state of hearing, suddenly they filed an affidavit. Almost the third affidavit. Earlier-
Regularize the services of the petitioner.
Yes. So.
Who are you?
Well, we are all fixed pay workers, my lord. We were initially appointed, my lord. One was appointed, my lord, way back in 1989. And the last one was appointed in 2006. So all of them have completed almost 20 years now in service. And they were, my lord, initially engaged, my lord, for, my lord, lesser amount. Then it came to, my lord, 2,000 rupees per month. Even that was also not being paid regularly. So they've admitted some of the areas being payable to us. About, my lord, 2 lakhs and odd. But
You
that
can
apart
get
from-
the minimum wages, that
Madam.
minimum of the last on wages, that's all. Minimum of the scale of
Meaning
pay.
of the scale.
That's
initially
Upen
that
Das.
was the framework, but the only anxiety is now that if, after giving the scale, they might just remove us. Now they're trying to say that we are not doing job, but though we are going there every day.
And what is the other matter for?
Other matter, my lord, is that suddenly they have taken a stand in the affidavit that we have been discontinued. The fact remains we are still going there, my lord, and we are, my lord, whenever whatever was asked, work is given.
Oh, I remember, yes.
Yes.
In this matter out there, you have challenged the second one,
Yeah.
challenging the,
Stand in the affidavit saying that we have been discontinued. No order has been communicated.
okay. On that day, I didn't want to issue notice,
Yes, my lord.
taking into account that are you not admitting it?
Yes, my lord. And the
Are
question
you
is-
not admitting that they have discontinued you by challenging the stand taken in the affidavit?
Because they have taken the stand before your lordship, my lord. So they have taken the stand that we have been discontinued. So I have to, my lord, challenge it otherwise. Otherwise, my lord, of course, in my reply, I have already said that we are still working in the first case. But here, as an abundant caution, my lord, we had no other option because it came up before another court, my lord, and the lordship was insisting that I should challenge this order. Otherwise, my lord, this case will be dismissed. So, my lord, I had this was my predicament. So I had to file it the second case, man. That's the problem.
In the earlier case, we have stated that they are not similar to those workers who are entitled for minimum
It's
pay.
okay,
Your lordship.
but the fact remains,
Lordship,
you say that you have discontinued them.
yes, your lordship.
They say that they are working.
Yes,
Shall we issue notice and maintain status quo?
yes.
Because if they are working, good.
Yes.
If they are not working,
Mhm. Yes, your-
meaning thereby don't discontinue because of the fact that the writ petition has been filed before this court.
but if they are already discontinued, it will be
That
the,
is why I'm saying
Yes,
status
sir.
quo as on today.
yes,
And I'll make it very clear that in the meantime, if you have already discontinued,
Hmm.
as on 1/11/2023, then no question arises. But if you have not discontinued, they would continue till the next stage. Because they have they are requesting for, they are paying for two things. One is a request of regularization
Yes,
on the basis of these new judgments passed by the Supreme Court. One is Sirpal and the other is Dharam Singh. And the second is as regards, the other thing is why should they not get the benefit under of Upendas?
Right.
Isn't it?
Right.
These are the two. Okay, issue notice returnable on, when do you want it? You have to file your affidavit.
yes, your lordship, lordship.
When?
Uh,
I'm taking this bench for some time, so
yes, your lordship.
you have to file your affidavit.
Yes, yes,
filing.
definitely, your lordship. We'll file your lordship.
Issue notice making it returnable on 19th of February 2026. I'm putting it on 19th, taking into account that it's a Thursday.
Yes, sir.
So you have to file the affidavit prior to that. Okay? Issue notice making it returnable on 19th of February 2026. Ms. R. Decker accepts notice on behalf of the respondent numbers
One, two, and
1,
three.
2, and 3. And Mr. So-and-so, Arbor Pujari accepts notice on behalf of the respondent number 4. You have no business. There is no 5 here. We have only till 4. Extra copies of the writ petition be served during the course of the day. This is the second round of litigation. Whereby the petitioners herein are constrained to approach this court, taking into account the stand taken by the Water Resource Department in WPC number 4997/2020, that the petitioners have been discontinued on 1/11/2023.
There are two dates, madam. One of them has been a petitioner, one on.
Have been discontinued on
Petitioner one on 1/11/23 and petition number 2 to 4 on 1/3/23.
in the year 2023. Full stop. It is a specific case of the petitioners that the petitioners are entitled to their services being regularized, taking into account that they have rendered service since the year 1989. And the inaction on the part of the respondent authorities to create regular posts thereby bringing the petitioners within the fold of the state government, services of the state government, is illegal and arbitrary. It is the further case of the petitioners that though such a stand has been taken in WPC number 4997/2020, that the petitioners have been discontinued in the year 2023, but the petitioner still continues to render services.
They've not been served with any order. They've not been served with any order.
Full stop. Mr. M. Dotto, the learned counsel appearing on behalf of the petitioner, submits that the petitioner has apprehend that taking into account that the present petition has been filed, the petitioners may be discharged from their services or not permit to render their duties and therefore seeks for certain interim directions. Per contra, Ms. R. Decker, the learned counsel appearing on behalf of the Water Resource Department, submits that the petitioner number 2 to 4 have already been discontinued with effect from 1/3/2023, whereas the petitioner number 1 has been discontinued on 1/11/2023. And as such, the question of such apprehension does not arise. The learned counsel for the Water Resource Department further submits that the question, as the petitioners have already been discharged, the question of regularization or payment of any or passing similar directions as has been passed by the learned division bench in the case of Upendas versus the state of Assam does not arise in the facts of the case. It is the opinion of this court that these aspects be brought on record by filing an affidavit by the Water Resource Department. And further to that, in the affidavit, should also be indicated as to whether the petitioners were duly intimated that they have been discharged from services as on the dates mentioned in the affidavit filed in WPC number 4997/2020. Taking into account the cross claims, the claims and the cross claims in the submissions made by the councils for the petitioner as well as the respondent Water Resource Department, it is the opinion of this court that certain interim directions are required to be passed till the next date. Under such circumstances, this court directs that the status quo as regards the services of the petitioners as on today be maintained, meaning thereby that if the petitioners are still rendering their services, they shall not be discharged till the next date. However, if the petitioner in the meantime have already been discharged prior to passing of the present order, there shall be no necessity. The status quo order shall have no impact. The other matter to list the matter on 19th.
Diplofix. May please, Your Lord. The petitioner, I'm sorry.
See, respondent counsel as a petitioner counsel, then I think we should help. Yes, tell me.
No, the petitioner before the Lord. Lord, he is a junior engineer, works in Tinsukia Division, NF Railway. Lord, the Oil India Authority issued an advertisement dated 18/7/2025, my Lord. That you'll also will find page 27.
27.
Page 27 is the advertisement. My Lord, the petitioner fulfilling the eligibility for grade 7 post, that you'll also will find page 28. He intended to, my Lord, submit his candidature against grade 7 post, my Lord. Accordingly, my Lord, he submitted an application before the railway authorities on, my Lord, 26/7/2025, page 40.
Which post?
Grade 7, my Lord.
Grade 7 has many posts.
My Lord, page 28, category,
Serial 9.
serial 9, my Lord.
C Roman 41205. Okay.
Yes.
Past class 10, past 3 years, diploma in civil engineering from a government recognized 11 vacancies. Then
So, my lord, intending to submit his candidature against this, he submitted an application at page 40, praying for NOC from the railway authorities, my lord. This was submitted on 26/7/2025.
Okay.
In fact, 25/7/2025, my lord.
Okay. Then,
My lord, the railway authorities, my lord, sat over this. I submitted my candidature by filing application page 41, which was accepted by the railway authority, sorry, Oil India authorities. I uploaded the application seeking NOC along with my application that was accepted by the All India authorities. And thereafter, my lord, computer-based test was held on 6, 8, 9, 10 October 2025. I participated in the selection process. Page 45 is the marks. Serial number 55 is the petitioner. He scored 73 marks. Now, my lord, the Oil India authorities published the select list, my lord, provisional select list, as well as fixing date for document verification, page 70.
where is your name?
My roll number is at, my lord, serial number 3 of C14
Page,
CIV 1025. Page
Page,
70, my lord.
page 70 only.
Yes, page 70, my lord, the third chart. List of shortlisted candidate in order of merit for document verification for postcode T1 serial number 3, my lord. So my merit position was at serial number 3 out of the 11 posts.
Oh, you are applying for this one, INS or this one? CD 1205.
12025. my lord.
Okay, the
This is
serial
my-
number 4.
Last 070, serial number 3.
10. Okay.
This list of shortlisted candidate in order of merit for document verification of postcode.
So your name is at serial number 3.
Serial number 3, this is my roll number, my lord, 00070,
So your document verification is on 19.
19/1/2026.
Again,
Till 19/1/2026, my lord, the railway authorities did not give me the NOC, they kept everything pending. It was on 12/1/2026. The Tinsukia division forwarded my NOC to headquarters, Maligaon, saying that the NOC will be approved only by the headquarters. That, my lord, will find page 63.
then
Then on 19/1, my lord, when I requested the Oil India authorities that kindly give me some more time so that I can get the NOC or I can pursue the railway authorities, they are contemplating to cancel my candidature. They are saying that in the final list, which will be published after a week, my lord, my name will not be there because I failed to submit the NOC from the railway authority. Look, one aspect is clear.
where is that page? Where is your intimation? Page 73.
There's no intimation.
Verbally.
On 19/1, yes, when 19/1, when I appeared in the document verification, they told me, my lord, I have made categorical statement also to that effect. They told me that after a week, the final senior select list will be published, wherein your name will not be there, and the person next to you on merit, he will be given a, his name will be there.
Then
There is a email, my lord, page 73. Last serial number elongated page, my lord. Serial
Then?
number 11. No objection from the present employer if applicable in case the candidate fails to submit NOC at the document verification stage, her candidature will not be considered.
where?
Page 73, my lord.
Where?
Last line, my lord, down below, clause 11.
Clause 8, 10, 11. Page 74 only. Clause 11 is there.
73 is also 73, my lord, this one.
73, which one?
Last, my lord, clause 11.
Clause 11 is
No
9,
objection,
10.
sir.
Page 73 is 10. You are referring to annexure P10.
P10.
Number 10 is oil, number 9 is oil apprentice candidates are required to submit national apprentice certificate.
My lord.
10 is photo passport for WCL.
11 is there, my lord.
Huh? There is no 11 here.
11 to. I think I use.
You have given some other people.
But, it's there in perhaps Milord while copying, making photocopy that. Even then, my lord will find
Page 74 second last clause
Second-
is also indicative of the said fact.
Where
page 74.
Second last clause.
candidates who successfully clear the document shall be considered. No, where? The
As per-
final selection is subject to candidate meeting all eligibility criteria as notified in so and so. The final list will be published in the official Iman in so and so. Please note that so and so of the account during verification of stage of the candidates may be rejected if documents are not found to be in order and Iman. Whether it is detected that the candidate has furnished an incorrect so and so. Where about the NOC?
NOC is one of the documents they sought by virtue of the
So
advertisement.
you are referring to which one? Please note that as per clause 6.0 Roman 4, is it? No,
Yes, yes.
Yes, my lord.
of the aforementioned advertisement. During
Clause 6 criteria
document
includes the
verification at
NOC.
any stage of the selection proceeding, the candidates may be rejected if the documents so and so are not found to be in order or as per requirement. Further, it is to be detected that the candidate has furnished any incorrect, doctored false so and so will cancel and the name of such candidate will be blacklisted for applying against so and so.
My lord will also have,
Who successfully clear the document here shall be considered here. Anyways, the long and short story of yours is you cleared out, you were earlier a railway employee,
yes,
you cleared out and without the NOC you participated in this recruitment process. You passed that examination and you were at serial number 3
Yes.
out of the 11 jobs.
Correct.
So you should therefore be getting it.
Yes.
But the fact that because of the NOC not given by the NF Railway,
and kept it pending.
there's a likelihood
Yes.
that the IOCL will cancel, taking into account that 19/1/2026 was the date of verification. What happened on the date of the verification?
On the date of document verification, my lord, I paid before the authorities that the NOC is not there with me.
Where is your prayer? Verbally.
Verbally.
Verbally, okay.
I prayed that this document is not there with me. I prayed for some time so that I can get the document or persuade with the railway authorities because I submitted the application in July 2025, praying for NOC. That was forwarded by the railway authorities.
So you are aggrieved with the action of the railway or Mr. Ansuman Sharma?
Today, my lord, my grievance is that, my lord, I'm praying for interim direction that my candidature may not be cancelled, my lord.
For how long?
My lord, at least some time, my lord.
No, do you show me a right? You knew about the date, on the date on which the result was published. 19/1/2026 is the date on which you had to get the papers.
Yes, true, my lord. But my lord, that's why I submitted my application for NOC in July. Also, will kindly have a look, page 40, the casual approach of the railway authorities that they on 12/1/19 was the DV, 12/1/2026, the Tinsukia division forwarded it to headquarters that a list of candidates were there, my lord, who sought for. My lord,
Now, what happens if the railway reject your application? Because you see, if you have the NOC, then I think you get the benefits of some pay also, no?
Yes, my lord, may I just pray? The rule for granting NOC has been incorporated in IRM 1401. It clearly provides that if a railway employee will get 4 chances to ask for NOC.
Where?
Lord, last page 76.
4 opportunities in a year
Yes,
to
it
apply
also
in
says-
response to the notices of the government, so and so. Only so and so we're holding it. Thought it should interpret the term public interest.
And it also says that it is not a rule. Rejection is not a rule, it's an exception.
Where,
In note,
Show me that.
note.
Note.
The
Why you are
authority
on
should
note?
interpret the term public interest strictly subject to the condition that the forwarding of the application should be the rule rather than the exception. In taking the decision to withhold the application, the competent authority has to balance the interest of the state against the necessity of causing hardship to the individual. This discretion should be applied with utmost objectivity and not mechanically. While it is not feasible to lay down the specific exhaustive guidelines for withholding of applications, some of them can be listed illustratively as follows. The railway employee is engaged on important time-bound projects and work could be seriously dislocated if he is relieved. Number 2, a railway employee is under suspension or facing departmental prosecution in a court. And number 3, a railway employee is applying for a
Come to number 3. Do you fall within number 3?
Yes, junior engineer, the pay scale is lower and
Applying
this
for a
class 7 is higher, pay scale is higher below.
So you don't fall within this exception.
Below. And on 19-1, I approached my immediate superior authority, Tinsukia Milot, base 75. Saying that
So,
kindly
Mr.
put on
Sharma,
the-
what should I do?
So may I just submit my predicament and my side of the case?
Please.
We have held the recruitment process with certain terms and conditions. We are following our terms and conditions. If your lordship will kindly come to the advertisement.
No, tell me one thing.
Yes, lordship.
Whether in the advertisement it is mentioned the date of verification,
Yes, date of verification.
is it mentioned in the advertisement?
No, it is not mentioned.
So it is based upon that your convenience. Date of verification is not touching upon.
Yes, lord.
You will verify is a clause of the advertisement.
Yes,
But the date of verification is upon your convenience.
yes.
So therefore, this convenience can be a bit extended to meet the interest of justice. In the meantime, let us ask why the railway is not there.
Yes, no, that I understand. But what happened was after the CBT, the computer test results were declared. Thereafter, this date was given, 19-1, this date was given.
You have to also understand,
I
he had applied. You see, I'm not going to touch on the clauses of the contract or the clauses of the advertisement. But the date on which the verification is to be carried out
Yes,
is a date on which it is your convenience by which you have fixed it.
which is already over now.
It's okay, it's
Yes.
over. But it can be very well extended. There's no quarrel that it cannot be extended.
Insofar as his case is concerned.
Only for that. Till then, let us ask the railways why they have not given. If they say that it falls within these exceptions and for which it is not being given, then in that case, obviously, he is
As of
taking-
now, the final selection list post the document verification is not yet out.
So
And the
therefore,
authority says another 1 week time will be required for
so
that.
therefore, let us have this matter again on 9th of February.
9th of February.
9th of February. In that, till then, they should either consider his application, reject, allow, whatever may be, and do it, finish. That is an order to that effect. You do whatever you like. You may reject it, but if you reject it, then also you give it, then he loses his job. That is the subject matter of another challenge. But if you give him, then obviously it will take care of.
Some protection will get that.
That is what I was saying.
Highly-
What else?
Yes, correct. I'm sorry.
And-
sorry.
Till then, lordship, what will all India authorities do vis-a-vis his candidature?
Not to cancel it,
Not to cancel it, yes.
not to cancel.
Only
No,
regarding his
to
candidature.
await his document verification to extend the document verification date to the beyond 9th.
Only regarding his candidate. That's what I'm
Only
saying.
he.
Because the other candidates also.
No,
That's
no,
what I'm
not
saying. It should
others.
affect them,
Okay.
your lordship.
You listen to what I am passing the
Yes,
order
yes.
now. I'm just taking
But
first.
otherwise, this submission of this document was a part of the advertisement conditions itself.
Understood.
He was
There's no
supposed to have
quarrel.
said that date.
No, there's no quarrel with that. But the date which you have fixed is the thing which you are doing it as well. That is not a part. He has to submit the NOC is not a problem. He
Of
has
the
to
advertisement, yes.
submit the NOC is a condition of your advertisement.
Yes.
Without the NOC, he cannot get the job. There's no problem with that.
NOC to be submitted when he uploaded his candidature at that point of time, 18/7/2025. We gave him this relaxation for 6 months. And on 19/1 also, he could not submit and he gave an undertaking to us.
Where is your relaxation given that he was submitted to submit the NOC later?
That document is not with us, but it's a fact that it was given. He has written that, Your Lordship. In his petition also, he has admitted
My
petition.
friend is saying that it is a relaxation. There is no relaxation clause. Since from the date of application and till the date of document verification, my lord, I failed to submit. My brother is saying that is a relaxation given by them. No, tacit approval.
Because
There is
otherwise,
nothing written that some relaxation is provided in the advertisement.
Anyways, let's see.
It's a it's logic.
Issue notice
condition of
making it
advertisement except on this.
returnable on 9/2/2026. Mr. A. Sharma accepts notice on behalf of the respondent
three,
number 2,
2 and
3, 2 and 3.
yes, Lordship.
Mr. DJ Das accepts notice on behalf of respondent number 1, 4, 5, 6, and 7. Extra copies of the writ petition be furnished to the learned counsels during the course of their reign. The petitioner herein was appointed as APPR.JE/works in level 6 by the NF Railway on 22/12/2022. When were you confirmed?
My lord, page 25, my lord. After training, my lord, this was the posting order, my
The
lord.
petitioner thereupon was confirmed. What is the name of the petitioner? Dipanjal Das. Was thereupon confirmed
As JE works
as JE Works
in Tinsukia division.
by the order dated 19/6/2024. Full stop. The respondent number 2 had issued an advertisement dated 18/7/2025 inviting applications from eligible candidates for various posts. The post in question, which is relevant for the purpose of the present writ petition, is the post at serial number 10 of the said advertisement, bearing postcode number COM 12025. Oh, no. Serial number 9. That is bearing postcode CIVI 2025.
One.
Full stop. The petitioner applied in pursuance to the said advertisement. And a provisional select list was published. Wherein published on 12/12/2025, wherein the petitioner, having secured 73 marks, was held to have passed. Subsequent thereto, a list was published by the Oil India Limited of the shortlisted candidates in order of merit for document verification. First, the petitioner was at serial number 3 and the date of document verification was fixed on 19/1/2026. First, next. At this stage, it is pertinent to take note of another aspect of the matter. The petitioner at the time of applying pursuant to the advertisement dated 18/7/2025 had submitted an application to the respondent number 5, isn't it?
Yes,
5 or 4?
1 second.
Divisional Railway Manager, this one number
Five,
5. Respondent number 5. Seeking no objection certificate for applying for the post. The said communication was issued, the said request was made by the petitioner on 25/7/2025. The materials on record prima facie show that till 12/1/2026, the railway authorities set over the said application. And it was only on 12/1/2026, the senior divisional engineer, NF Railway, had forwarded the assistant personnel officer oblique Roman 2 for divisional railway manager P forwarded the petitioner's application when petitioner's application to the senior DEN. Who is DEN?
Senior divisional engineer. Senior
Yes,
DNC.
to the respondent number
Respondent number, my lord?
6.
6.
To the respondent number 6.
And senior DNC forwarded to deputy chief engineer, page 63.
Kustum. Thereupon, the materials on record further show that where is the document?
Page 63. APO forwarded to senior DNC and senior DNC forwarded to deputy chief engineer Maligaon, page 63. Same thing.
Subsequent thereto, or on the same date, the senior divisional engineer, that is the respondent number 5, forwarded the petitioner's application to the deputy chief engineer. He is not a party.
Mainly, call has to be taken by the general manager. No? Headquarters is headed by GM, my lord. Although he is a forwarding authority.
To the deputy chief engineer, oblique G oblique MLG. Kustum. In the meantime, on 19/1/2026, the petitioner could not provide the NOC. The petitioner verbally requested the authorities of the Oil India Limited to grant him some more time so that he can produce the NOC. It is, however, it is the allegation of the petitioner that the respondent, Oil India Limited, however, declined to consider the request so made by the petitioner. It is the apprehension of the petitioner, therefore, that though that the petitioner now name would be dropped from the said recruitment process and the said post would be offered to the next meritorious candidate. It is under such circumstances the petitioner has approached this court by filing the present writ petition. First, this court have heard Mr. A. Sharma, the learned counsel, appearing on behalf of the respondent number 2 and 3, who submits that the petitioner were required to produce all the necessary documents at the time of document verification, which the petitioner very well knew was fixed on 19/1/2026.
So my argument is a bit different. I say that as per clause 6 of the advertisement, these documents were supposed to be uploaded at the time of the application itself. That's clause 6, it's there. He did not give it. All India allowed him time till the document verification stage. That was after 6 months.
But that is verbally.
That was verbally. As of now, I don't have the instructions to that regard in writing, but that has been communicated to me.
Okay.
And it's a fact because he admits to that.
Mr. A. Sharma, the learned
Clause 6
counsel,
of the
appearing
advertisement.
on behalf of the petitioner, respondent number 2 and 3, submitted that in terms with clause 6, the petition of the advertisement, the petitioner was required to submit the NOC at the time
Uploaded at the time of online
at
application.
the time when the petitioner submitted his online application.
Yes, that's the clause. That's the clause.
However, in spite of the petitioner not submitting the said NOC, the respondent, Oil India Limited, had granted the petitioner an extension, had granted time to the petitioner to submit the said document, said NOC, at the time of document verification.
Yes, laws.
He submits, therefore, that as the petitioner had failed to produce the NOC at the time of document verification, the petitioner has the instant writ petition so filed by the petitioner is misconceived. Full stop.
One more argument is
Yes.
on the day of that particular document verification,
Mm.
he gave an undertaking saying that I understand that I didn't give this document and therefore my candidacy is cancelled and I will not file any complaint or objection to that. So how do we treat this document also will be another aspect. I needed to place this for your lordships.
Look, so far as this is concerned, my lord, I have made a categorical
Yes, it
statement
is there.
at para 21 of my writ petition.
Lordship will see the clause 3. This is his undertaking. So I also need to take account of this document also as an authority. My candidacy stands cancelled and I am unable
What
to.
do you say about this document?
Para page 20, para 21, my lord, I have stated on 19/1/2026, when I produced one letter that is page 75.
Have you asked for declaration that this is bad under coercion?
My lord,
Have you sought
Yes,
for
yes.
that?
Para 21, I have categorically stated, my lord. I'll just read, my lord. The petitioner begs to state that during the document verification process on 19/1/26, he requested the Oil India Limited authorities with folded hands to grant some more time to produce the NOC. The petitioner showed all his communication with the railway authorities to the authorities in the Oil India Limited, but the Oil India Limited authorities are adamant not to accept any of the prayers of the petitioner. The Oil India authorities also took a declaration from the petitioner by taking his signature on a format that the petitioner will have no objection in the event of cancellation of his candidature. Such declaration taken by the All India Limited authority is absolutely
Okay,
unconscionable.
Oh, it's okay. Okay.
Lesser by
Mr. A. Sharma further submitted that apart from that, the petitioner also do not have any case, inasmuch as the petitioner had given an undertaking before the respondent number 2 and before the Oil India authorities of the Oil India Limited during the time of document verification, that as he had failed to produce the NOC on 19/1/2026, he shall have no claim against the postcode C1V12025 of Oil India Limited. Full stop. In that regard, he has placed an undertaking, the undertaking before this court, which is kept on record and marked with the letter X. Full stop. This court also inquired with Mr. D.J. Das, the learned counsel who appears on behalf of the railway, the NF Railway, as to why the petitioner had not been issued the NOC. He submits that he would obtain instructions in that regard. Full stop. Mr. H.K. Das, the learned counsel, appearing on behalf of the petitioner, rejoining his earlier submission, submits that this document, this undertaking was taken from the petitioner under caution, and in that aspect had been alleged in paragraph number 21 of the writ petition. He therefore submits that the petitioner herein is at no fault for not being able to produce the NOC, in as much as the NF Railway have arbitrarily and illegally withheld the said application filed, the NOC. This court have given an anxious consideration to the respective submissions and is of the opinion that certain directions are required to be passed in the interim till the next date. Full stop. Number one, it is seen that the respondents, it is taken note of that though, as per clause 6 of the advertisement dated 18/7/2025, the respondents, Oil India Limited, the 85, 25, it was the requirement that the NOC should have been uploaded along with the application. But the respondent, Oil India Limited, have permitted the petitioner to submit that document at the time of document verification. It is also duly taken note of that the petitioner has not been able to produce the document, the NOC, on account of the inaction, prima facie, on an account of the inaction on the part of the respondent railway authorities in take for consideration of the application of the petitioner for consideration of the application filed by the petitioner seeking the NOC. Taking into account the above, this court directs that till the next date, under such circumstances, it would be in the interest of that justice that a direction should be passed in the interim to the railway authorities to forthwith consider the application filed by the petitioner seeking NOC. First, number two, the railway authorities, the NF Railway, the respondents in the NF Railway are directed, therefore, to dispose of the application filed by the petitioner seeking NOC within, on or before 6th of February 2026 as per its own guidelines. Number two. Number three. This court further directs the respondent oil not to reject the candidature of the petitioner in respect to the post wherein the petition in respect to the post bearing postcode number C1V12025 till the next date. Now, wherein the petitioner have been provisionally selected till the next date. Full stop. Number 5. full stop. The above directions, however, shall not in any manner hinder the recruitment process so initiated by the Oil India Limited in respect to all other posts.
Obliged, Your Lordship. That was my concern also.
Be clear.
It's longer than a judgment. A lot of motions are coming. Where is it? Yes, what is it?
My case is promotion from Anganwadi helper to Anganwadi worker, Your Lordship.
Promotion. আগতো আপুনি মাৰিছে ন এইটো এই অৰ্ডাৰটো এইমাত্ৰ অৰ্ডাৰটো যে মাৰিলে আপুনি লৈছিল ন আগৰ মোচনটো বেলেগ কাৰোবাক মাতি দিব একেইটোক মাৰি দিব দিব কাৰণ মই এটা বজাত গুচি যাম ন লম্বা আছে এইটো ন Yes. So goes as to why retailer should not be issued directing the respondent, especially the child development and business to promote the petitioner to the post of Imam as per guidelines.
As per guideline, Your Lordship, I am fit to.
How can I give a direction to promote?
Annex 5.
I can only give a direction that he should be considered. Anyways, what is you are working as Anganwadi helper. You want to be a worker.
Inserts of Anganwadi worker.
Huh?
Then inserts Anganwadi worker.
You are Anganwadi helper.
On 13/7/2007, Annex 3, page number.
Where is your appointment letter?
Page number 19, Your Lordship, Annex 3.
Huh?
Number 19.
Page number, no, where is that? Your appointment order is where?
13/7/2007.
Page?
Page 19, Annex 3, 19. 18 to 10.
Okay, English version is page 18.
18.
That you are engaged as Anganwadi helper at so and so as per examination. Now, what do you want?
Now, Lordship,
These guidelines
And
shall into
above
force on so and so
here,
only
for
those
your
Anganwadi shall be eligible for
Anganwadi
promotion
workers
under the
are
scheme who have
workers
been in
by-
continuous year for demand and above as Anganwadi in any duly signature, only those years. So, you say that you have completed 10 years.
Yes.
10 years?
10. Fulfill all the criteria as per guidelines, Your Lordship, Annex 5, page number 21, Your Lordship.
Ah, so
Already
now you have not been considered. Oh.
Submitted depend.
Upgradation from here to Anganwadi worker. Well,
6 years before Anganwadi worker, namely Hasina Khatun, expired, Your Lordship.
now there is another year, you are above 50.
No, 40.
The Anganwadi helper to be eligible for promotion under this scheme shall be, not be above here at the time of consideration of our promotion. So you are 40.
48.
40.
Earlier 45 years. and
Oh,
later
if
20
2
years.
years is passed by, then you are out.
Lordship already.
Lordship, her representation is pending.
Okay.
Page
Issue
number
notice
23.
making it returnable
Now
on,
age is up to 50 years. As per.
you are
age
50?
24. I am 48. Yes.
You are 48. So we have to finish it as early as possible, no?
Really extended up to 50, 24.
Shall
And my representation is pending, Your Lordship, for consideration. Page number 23, Your Lordship.
issue notice making it returnable on 23rd of February 2026. Mr. D. Bora accepts notice on behalf of all the
All
respondents.
the respondents.
Extra copies of the petition be served upon him during the course of the day. The petitioner herein was appointed as an Anganwadi helper at Sirakua Part 5, 116 number Anganwadi Center by an order dated 13/7/2007. The petitioner have rendered service for more than 18 years as on date. Full stop. It is also the case of the petitioner that because of her works, she has also been issued certificate of appreciation. However, the petitioner have not been considered for promotion to the post of Anganwadi worker in spite of the mandate of the notification dated 4/3/2013. The petitioner had submitted representation which have not yet been considered. Resultantly, the petitioner therefore has approached this court. The respondents herein are directed to apprise this court by way of an affidavit as to why the case, as to whether the case of the petitioner have been considered, and if not considered till date, why so? The affidavit be filed on or before next date kiriya কৰিছো 23rd na? On or before 18th of February 2026. List according. Yes. Who is the petitioner? Petitioner, kindly come here. I don't take up stay vacating like this. I always say the state vacating application has become infructuous in view of the judgment passed. So therefore, we'll go for the judgment. What is your case?
So here in this case, Lordship, the applicant is the respondent number 6, Lordship, in the writ petition, Lordship. So I preferred this interlocutory application, Lordship.
You are not appointed and you are continuing
Yes, continue.
as a Gaubura.
Yes,
How?
Lordship. He was appointed initially as a governor. And I preferred appeal before. And as because considering his this medical condition, his appointment was cancelled and I am being appointed, I am continuing.
How you have been appointed?
Lordship, I was also a candidate, Lordship. Second
So
candidate.
candidate they can appoint. There is a wait list concept in Gaubura.
I was the second, Lordship.
So is there a wait list concept? Then how can you be appointed? If he can't be appointed, he's gone. That's a different aspect of the matter. But you can't be there. Huh?
Yes, Lord. The order itself also reflects, Lordship, the review order, Lordship, that, Lordship, a fresh selection may be held, Lordship, after consideration of my health condition by the appropriate board, Lordship.
Yeah.
So then there are no wrong in the.
Otherwise that you can continue. You are number 2. Where is this? This is it's like a bidding tender. Matter over. Before starting.
Lordship, Lordship, he was at the time of selection, Lordship, he was having Parkinson's disease. Lordship, he
Whatever
was
may
very-
be, whatever may be, it is wrong. Maybe he has been wrongly selected. But the fact that how can you be
It's a
clear?
equal-
If
it's
the
a
selection will be bad, the selection can be set aside. But how can you be allowed? There's an interim order.
Yes, Lordship.
Yes, Lord.
My goodness. Operation of the order dated 15/5. What is this 15/5 order?
This is the review order, Lordship. Which is,
But you are challenging 17/2. Huh?
no, that,
What is your petition? Page 19?
Repeating of 19.
He did sign on 15 lordship, but because of 17-2.
Where is the original order?
Original order is at page 29, Lordship, the review order, Lordship, of my application. Lordship.
You have filed. Your name is
Uh,
Sirajul.
My name is Akhtar Hussain, Lordship.
Your name?
Is Sirajul.
Sirajul. Okay. So you state that the appeal be admitted for hearing and Ivan. And secure the serious and position for an understanding that the applicant appellant is the son of the Scarborough is working in the Indian. But this order is wrong. That first order. Without medical report, he is saying this. That the appellant Sirajul could not qualify in the interview, but being the son of executive having experience and fit for better service in the Iman, the appropriate appointment order of so-and-so is hereby set aside and cost with a direction to give the deputy commissioner to consider the case of so-and-so as the Gaubura of so-and-so. Yeah. Then the deputy commissioner considered it.
Yes.
Where's your appointment?
One order pass.
Huh?
Case 35.
For the purpose of money, it is evident that when complaint arises, Sirajul who is appointed to in the post of Iman. So you have been appointed temporarily.
Yes.
Yes, sir.
Then
I have been appointed and I am continuing.
no, you are appointed temporarily. That's your appointment order, page 33.
Yes, sir.
Till a fresh selection is not done. Otherwise, you are not appointed permanently.
This appointment is not done yet. They preferred appeal against this particular order.
They prefer the review.
Review. Then review lordship.
Review is by the Revenue and Disaster Management.
Yes.
Page 50 lordship. In page 51 lordship, the elements.
Right order. And you were appointed temporarily also. You are not permanent.
But
You also know your fate. Anyways.
But the review lordship, the page 51 lordship. I'd like to point out the page 51.
Oh?
That is the impugn order lordship or my petition lordship. That is the last but one.
Where?
Commissioner Nagaur. District Commissioner Nagaur, white letter number so-and-so, furnish the medical fitness certificate so-and-so in respect of Akhtar Hussain examined by the District Medical Board, Nagaur. Wherein it is certified that the review petitioner is having symptom of Parkinson and currently not fit for skill work. In spite of this lordship, and in spite of the fact that in a original advertisement also, there is a condition of medical and physically and mentally fitness. In the exclusion clause also, there is clause that he should be medically and physically and mentally fit. And in spite of the fact that he is currently having Parkinson and not fit for skill work, the review board.
So you want to be a permanent Gambura or a temporary Gambura?
Lordship, I am being continued. This
No, you
observation.
cannot continue. And have you been receiving any salary?
Lordship,
You should return it back, no?
Lordship,
And getting a stay also. In this type of matters, very difficult.
My lord, even then, lordship, in the order itself, lordship, there are no direction that I.
Now apply out there, you fresh, you are the son. You'll get 10 out of 10 marks.
no, Lordship, that is also one of the qualifying condition also, that preference may be given. Not much, Lordship. I got 36 marks and he got 44. I do agree. But one major condition is that one should be physically and mentally fit for the work.
What is his age?
He is having Parkinson, Lordship.
What is his age?
My lord,
Oh, you don't know your client's age.
I know, lordship. Age is, lordship, 39 years, lordship.
Huh?
39 years.
39 and Parkinson.
My lord, even at the time of appointment, lordship, there are no such things.
Ah, very difficult to find.
Some-
Parkinson does not develop so early.
47 years.
Huh?
47 years.
Yes.
Yes.
You don't know your client's age. Are you
47.
representing your client or not?
Extremely sorry, my lord. This is
Huh?
somewhere lordship written as 39. But
Somewhere written.
This Sirajul's lordship.
He is 39.
yes.
Hello?
There is table of all four limbs started.
Show me
Right.
the executive instruction says that if the selection of a AI is bad, the next one should get it.
There is no specific.
Matter over. The selection, once a person has been appointed, something has happened out there. So then his selection has gone. You can only ask for a surgery for setting aside his selection.
Yes.
And this order is right. And you have been appointed temporarily. Don't you want to be permanent? Chalo. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. And Mr. S. Dotto appears on behalf of the Revenue Department of the Government of Assam. And Mr. So-and-so, who appears on behalf of the respondent number 6. The present writ petition has been filed challenging the order dated 17/2/2025 passed by the Secretary to the Government of Assam Revenue and Disaster Management Department, which was digitally signed on 15/5/2025. Full stop. For the purpose of deciding the legality or validity of the order dated 15/5/2025, the impugned order dated 15/5/2025, it is relevant to take note of the brief facts which led to the filing of the instant writ petition. Pursuant to an advertisement dated
Two five 2017.
2/5/2017 for appointment of Gaon Pradhan of village Honari Gaon, the petitioner as well as the respondent number 6 participated in the said selection process. The respondent number 6 secured 44 marks and the petitioner secured 36 marks. Under such circumstances, by an order dated 28/2021, the Commissioner Central Assam Division Nagaon Under such circumstances, when were you appointed?
I was appointed on 29/7/2017.
Huh?
Initially, he was appointed on 29/7/2017.
Under such circumstances, the petitioner, the respondent number 6 was appointed as the Gaon Pradhan. Gaonbura, Gaon Pradhan.
Gaon Pradhan now.
Gaonbura. Gaonbura koi dibo dei.
No, they are Pradhan.
On
29/7/2017.
29/7/2017. The petitioner herein being aggrieved preferred an appeal before the Commissioner of the Central Assam Division, Nagaon, in terms with Section 162C of the Executive Instructions under the Assam Land and Revenue Regulation 1886. The said appeal was registered as case number RR CAD 39/2017. By an order dated 28/2021, the Commissioner, Central Assam Division, allowed the appeal, holding inter alia that the respondent number 6 was physically challenged person and not fit to carry out his work smoothly. The Commissioner, Central Assam Division, further observed that though the petitioner did not qualify in the interview, but being the son of ex-Gaonbura, having experience and physically fit for better service in the public and government, the appointment order of Mohammad Akhtar Hussain Gaonbura issued by the Deputy Commissioner Nagaon was set aside with a direction given to the Deputy Commissioner Nagaon to consider the case of the petitioner afresh within 30 days from the date of receipt of the order. Upayukta would be Deputy Commissioner.
Yes.
Here you have mentioned as Commissioner. Why? Translation wrong. Pursuant to the said order dated 28/2021, the Deputy Commissioner, Nagaon, by an order dated 25/11/2021, temporarily appointed the petitioner to the post of Gaon Pradhan. Now Pradhan or Gura?
Now Gaon Pradhan. Earlier it was Gaonbura.
Gaon Pradhan. With a stipulation that if there is a complaint against the petitioner who is appointed temporarily in the post of Government Gaon Pradhan, it would lead to immediate dismissal from duty without giving any notice. Being aggrieved, the respondent number 6 preferred a review application under
Executive instruction.
Executive Instruction number 162D before the Principal Secretary to the Government of Assam Revenue and Disaster Management Department. By the impugned order dated 17/2/2025, which was digitally signed on 15/5/2025, the Secretary to the Government of Assam Revenue and Disaster Management Department had set aside the order dated 25/8/2021, passed by the Commissioner Central Assam Division, Nagaon, and with a further direction to the Deputy Commissioner, District Commissioner, Nagaon, to take steps for appointment strictly in accordance with the provisions of the executive instructions against the vacant situation of the Gaon Pradhan of village Honari Kisam under Dhing Revenue Circle after assessing the physical and mental fitness of the review petitioner as required in accordance with the executive instructions. It is under such circumstances the petitioner, being aggrieved, has approached this court by filing the present writ petition. The record reveals that this court, by an order dated 26/5/2025, while issuing notice, had stayed the impugned order dated 15/5/2025. The record further reveals that the respondent, number 6, being aggrieved by the continuation of the interim order, have filed an application seeking vacation, modification, and or alteration of the order dated 26/5/2025. Today, the matter has been fixed before this court for consideration of the stay vacating application. It is the opinion of this court that any order passed in the said proceeding would have to be dealt on the basis of the merit, of purely have to be dealt on merit. And taking into account the above, this court therefore has taken up the instant writ proceedings for final disposal. I've heard the learned counsel appearing on behalf of the petitioner, as well as the learned counsel appearing on behalf of the respondents, Revenue and Disaster Management Department, and the respondent number 6. From a perusal of the materials on record, that it is apparent that in pursuance to the advertisement dated so and so, the data that is what?
Advertisement dated 2/5/2017. Advertisement dated 2/5/2017.
Not enclosed. Where is the advertisement?
Advertisement not annexed, Lordship.
Okay, advertisement dated so and so. The petitioner herein, the respondent number 6 herein, having secured more marks than that of the petitioner, was selected and appointed as the Gaunbura of Sonari Kisam Gaon
Lordship.
village.
Sonari
huh?
Kisam. Yes, Lordship.
Sonari Kisam village. An appeal thereagainst was filed by the petitioner in terms with in terms with clause 162 C of the executive instructions. It's a regulation 162
Executive instruction. Executive instruction.
of the yes. This court have duly taken note of the order dated 25/8/2021 passed by the learned commissioner, Central Assam Division. It surprises this court that the Commissioner, Central Assam Division, though could have very well set aside the appointment, selection and the appointment of the respondent number 6 on the ground that he was not physically fit. But to direct the Deputy Commissioner to appoint, to consider the Deputy Commissioner Nagaon to consider the case of the petitioner for being appointed as the Gambura of the village, in the opinion is in the opinion of this court, the Commissioner, Central Assam Division, have far exceeded his jurisdiction. it is the further opinion of this court that upon setting aside the appointment of the respondent number 6, the commissioner, Central Assam Division, could have very well directed for fresh selection. Full stop. The record further reveals that the respondent, that the Secretary, Revenue and Disaster Management Department of the Government of Assam have duly taken note of the said aspect of the matter and have passed the impugned order, which in the opinion of this court is in consonance with the settled principles of law. First, under such circumstances, this court does not find any ground for interfering with the impugned order dated 17/2/2025, which was digitally signed on 15/5/2025. The intent, in that view of the matter, the writ petition therefore stands dismissed. Interim order passed earlier stands vacated. In view of the judgment and order passed in so and so, I stands closed. वकालत तुम्हें कुने फाइल करेছে नाम দেখাইছে নাই and has appeared on behalf of the respondent on call in spite of the names of the counsels being duly reflected in the cause list. It is also seen that no affidavit has also been filed on behalf of the sole respondent. Considering the above, for the ends of justice, this court fixes this matter again on 9th of February 2026. 9th of February 2026. It is observed that on the next date, if the respondent is not represented, this court would be constrained to pass appropriate directions seeking his personal appearance.
That industrial tribunal matters. Industrial tribunal matter. We have paid for benefit of the Shakti Commission to the registrars of the industrial tribunals. Lordship was pleased to hear the matter earlier. My lord, one thing I find an additional affidavit, it might not may come to page 252. Come across this new document, my guy. The government has been pleased to invest powers of additional powers. This is signed on 28th of May 2024. The governor of Assam is pleased to invest additional power to the presiding officers of industrial tribunals of Kamrup Metropolitan, Kachar and Dibrugarh, as well as the labor courts of Kamrup Metropolitan and Dibrugarh,
for adjudicating judicial cases of civil, criminal, and MSc nature of cases, in addition to their powers to adjudicate industrial disputes and labor matters. Further, the services of the officers and staff of industrial tribunals and labor courts of Assam may be utilized in the process of adjudicating of judicial cases of other civil and criminal nature. My lord, thereafter, on the next page, my lord. My lord, proposals for for filling up of posts of, for creation of posts of head assistant in these tribunals, my lord, page 253. The proposal has been sent from. This is from the High Court, my lord. With reference to the subject cited above, the Office of the Judicial Department has requested the registry by letter number so and so dated 10th March 2025 to furnish proposal for creation of posts of head assistant and district level officers where there is no head assistant superintendent for creating promotion languages. The proposal had been sent, and interestingly, my lord, the proposal, the salary of the head assistant is more than that of the registrar. The proposed. That comes to page 255, my lord. The grade 2 given is 13,900 at page 255. Grade pay proposed, my lord, sorry, not given. And my grade pay, my lord, is 12,007 as registrar. All the other staff in the tribunal and the labor courts, they are enjoying the benefits of the shipping. Only the registrar. The reason given, my lord, is that the term or the designation.
Our division bench has held that the SETI commission is not applicable.
Fine.
A division bench has held that the SETI commission is not applicable. Isn't it, Mr. Das? Isn't it the order of the division bench that the SETI commission is not applicable?
Yes. But I was not aware of that. Sorry, my lord.
The judgment
And
on the stenographer thing.
I understand. And I think.
The division bench holds that the SETI commission is not applicable. So when the division bench has held that the SETI commission is not applicable, why is the state government paying these officers or the ministerial staff any amount as per the SETI commission? They should be reduced. Mr. Arbor Pujari, the finance department, reduce this amount, save some money for the state. The division bench has held the SETI commission is not applicable. Isn't it?
I think it is not with regard to pay and allowances.
Yes, pay and everything.
SETI
SETI commission not only said anything, the SETI commission not only said about promotion and all the avenues, also said about pay and allowances. So
that issue was
when the division bench is held that the SETI commission is not applicable, is not to be followed in the judgment, then in that regard, you don't need to follow.
no, perhaps that
Reduce
is
all pay scales.
division bench judgments may not be all pervasive with regard to pay and allowances.
No, it will apply
was-
for everybody because it says the SETI commission is not required to be filled up. The division bench said that the states, the High Court should take up on the administrative
Sir,
side.
I'll have to
should take
check
it up
once, my lord.
as regards how it is to be done as regards the draft rules. Now, they have not made the draft rules for that. They have been asked by the Supreme Court to follow the SETI commission. Now the division bench says the SETI commission is not required to be followed. So don't follow it. Although we have an committee for following the SETI commission that has become redundant by the division bench judgment. Isn't that the judgment? Let's see that.
My lord, perhaps division bench has said with regard to the given facts of this case. Because
No,
that was a
it's not a
given
given facts of the case. There is a specific mention
That is
that SETI commission's recommendations are not required to be followed.
SETI commission recommendation with regard to, my lord, this
It's not binding.
stenographer grade 3 and grade 4.
Whatever may be,
Grade 2.
no, it was said about grade 1, grade 2 and grade
In
3.
that case,
But the division bench said that the SETI commission is not required to be followed.
no, that has to be understood in the given facts of the case. my
No,
lord.
it categorically says that.
Maybe it has
So
to be
therefore,
said.
SETI commission is not required to be followed. So you don't get any benefit of city commission. You'll be given as per the industrial, what they are being given. We follow that
I'll again
judgment.
go through once
and
that
dismiss his
judgment, my lord.
petition.
Lordship, it's like to examine that.
Come minor prior to 2010. Now, when the pay scales are incorporated in the ROP, it has a minor historical background. It minor X stages, minor chronology.
No, the state is, no, the state is given certain advantage to the ministerial staff. City commission. Now, division bench says that the city commission is not required to be followed. So therefore, the petitioner case has to fall because they are not entitled to benefit. We hold that on the basis and dismiss his petition. Where is that judgment? What is the name of the judgment?
Read appeal 281 oblique
Ah,
2025.
It's reported in the GLT.
No, my lord.
It is.
No.
It is reported in the GLT.
Lordship's judgment was reported, my lord.
If you have the copy of the GLT reporting of my judgment, you will find it in the last judgment
I
of
missed
that
it.
issue itself that the judgment is
But
reported. There it is categorically says that the city commission is not required to be followed. And it gives us a very good advantage for us also to say that, okay, the petitioner is not entitled to anything as per the city commission in view of the division bench. Now let the division bench then take up as to whether it is right or wrong as regards the city commission. You can't, the division bench cannot, on the basis of saying that, okay, for this matter, city commission we follow. For this matter, city commission we don't follow.
No, perhaps, my lord.
So let us go by that judgment where it categorically says city commission is
No,
not
perhaps
required.
it has to be considered or appreciated with the given facts. In the case, what is the
No, in the stenographer's case, what was being done by the High Court on the administrative side? The High Court on the administrative side says from 2002 onwards that one-time exceptions. One-time measure from 2002, every time there was a one-time measure, which went even to the extent of in 2024 also, for the last 23 years, there was a one-time measure being adopted by the High Court on the administrative side. And that too without any quantifiable data. Then the question arose that the one-time measure, if it is adopted on every time, it becomes a recurring measure. It doesn't have the flavor of a one-time measure. So therefore, the question is, but the division bench said that the city commission is not required to be followed in this manner. The matter went to the Supreme Court. The Supreme Court has upheld the judgment. So therefore, city commission is not applicable. With city commission not applicable, the finance department can do whatever they feel like. You were all protected. The ministerial staff were all protected on the basis of the city commission. Let us see the judgment.
Judgment okay.
Hey, last tinikon GLT annexation. What was the name of the party?
Name of party is, my lord, Guwahati High Court versus Nazrul Islam Laskar.
Nazrul Islam Laskar.
No, that too.
And তাৰ পিছত এটা appeal হৈছে.
281 oblique 2025.
ৰেকৰ্ডৰ নাম্বাৰটো আছে ন গ্ৰুপতে তাৰপিছত পঠাই দিছোঁ এইটো পঠাই দি আছে ৰ'ব নেটৱৰ্কটো অন কৰিলোঁ
This is reported in 2025 SCC Online 4414.
Some other day we do this lordship's.
হ'ব যাব মোৰটো উইলো আমাৰটো উইলো না আছে এইটো কি হ'ল
Paragraph 48, Roman 4. In Amit Sinha Supra, it was not held by the Supreme Court that the recommendation of the SETI Commission to be considered construed as statutory, completely inhibiting the High Court to fix criteria for selecting best possible candidates in absence of any rules framed in that regard. So, So where SETI Commission is not to be followed in respect to stenographers who were from grade 3 were jumped to grade 1, although it was from grade 1 only, from grade 2 can go. There were one-time exceptions being granted, which went for the last 23 years. And though in Abhimit Sinha, it was categorically mentioned that if there were no draft rules, then in that regard, the SETI Commission is bound. But the division bench has held that it doesn't say that it is statutory. So under such circumstances, they cannot have a right. If they cannot have a right on the basis of SETI Commission.
One thing is settled that SETI Commission is a recommendation. In a SETI Commission is a recommendation, and for that purpose only there is
SETI
committee.
Commission was not only a recommendation. SETI Commission was a recommendation which was given at that point of time, and then the Supreme Court made it clear by one of its judgments in the All India
Judges Association.
Association, wherein it says that SETI Commission is to be followed. This happened in 94-95. When that has happened, the Supreme Court, both the High Court as well the High Courts constituted committees. And when there was a combined committee of both the part of two committees, one is for recruitment and the other is for implementation of the SETI Commission, a one-time measure was taken that at that point of time we were not having these stenographers to that effect. So one-time measure was taken. These one-time measures went for 22 years or 23 years. So thereupon, this court held that in view of this Abhimita Sinha, it is wherein at paragraph number 34, it was categorically mentioned that when there is no rules, then the SETI Commissioner's recommendation was binding. Then the division bench holds that this is not statutory. If it is not statutory, it's merely a recommendation.
Yes.
If it is merely a recommendation, the petitioner has no case. Matter over. Bad case.
Back on Samad again.
Huh?
Lordship, back to on Samad again.
Have it.
Listen,
Have the judgment. Because you see, what this Abhimit Sinha say, see this judgment.
I think relevant paragraphs was quoted. 20, it was placed by me only during hearing. Because 20.
Paragraph 59. With the above pronouncements on the interplay between the SETI Commission's recommendation and the prevailing rules, the following logical deductions can be laid down. In case of inconsistency between recommendation and the rules, primacy should be given to the existing statute rules. In absence of existing rules, the High Court should follow the directions of this court. That is, the directions passed in 1992 that implement the SETI Commissions. So therefore, this is what was given. Now, SETI Commission is not binding in view of the division bench. Doesn't have a statutory force, matter over. So we dismiss it, go to the division bench, they may help you.
Supreme Court's order, my lord,
Hmm?
the earlier order, my lord, of 2009 to ensure implementation of the SETI Commission, implementation of the judicial side.
So the division bench on the judicial side have taken a totally 180-degree somersault. So therefore, now you cannot. That's the law. Division bench may help you out. Yes, Mr. Arba Pujari. What do you have to say?
48 is.
Oh,
Nozrul Islam Laskar, division bench decision,
ah.
which lordship has not deferred. My learned colleague has relied on Abhimit Sinha, but then Abhimit Sinha has been observed, my lord,
Hmm.
to the effect that SETI Commission doesn't carry any statutory force.
Hmm.
Now, these pay scales were incorporated in pursuance of recommendation at that point of time, of course, that is the admitted position. And then, my lord,
It was not held by the Supreme Court the recommendation of the SETI Commission to be considered construed as statutory, completely inhibiting the High Court to fix criteria for selecting the best possible candidate in absence of any rules framed in that regard. Now, there is no rules framed.
yes, second issue that will fall down will be, my lord, the rules.
There is no rules framed for them.
Rules.
So under such circumstances, the recommendation of the SETI Commission would have no value.
SETI Commission
As per the division bench.
Yes, SETI Commission recommendation.
I don't agree, but I'm bound.
SETI Commission's recommendations were acted upon prior to 2010, when the 6th Pay Commission came. And thereafter, usually, my lord, those scale of pay were incorporated. Now here,
Listen,
my lord,
we do one thing. We simply dismiss your petition on that basis. That in view of the observation of the division bench in this, about the SETI Commission,
Abhimit Sinha to Assembly.
and your entire case based upon the SETI Commission's recommendation.
Abhimit Sinha to
So
Assembly.
therefore, let the division bench take a call now.
Perhaps, my lord.
Perhaps, my lord, that judgment of the division bench was on recruitment, my lord.
So what?
Now, report.
So what? No. You see, the division bench categorically holds that the SETI Commission is merely a recommendation. It doesn't have statutory force. And therefore, it does not stop the High Court. Now, High Court cannot touch on the salary. This is a very important aspect. As regards salary, it is for the state. The state tomorrow, in view of this judgment of the division bench, which says that Seti Commission has no statutory force or has nothing to do, the state can give anything, may give you tomorrow peanuts. What you were protected with was a barrier, a bar by Seti Commission.
That the division bench
Yeah.
has.
But the division bench, in order to save itself from the fact that it was not a recurring, and they can do away with the SETI Commission, had held this aspect in paragraph number 48. It is not required. Although paragraph number 59 of Abhimita Sinha categorically says that if there is the inconsistency between the SETI Commission and the rules, then the rules will follow. When there is no rules, it is the court's orders of the court, meaning thereby to implement SETI Commission. Because if you see, I'll tell you when the SETI Commission was implemented.
1st of April 2003.
No, I'll show you how it is. In the year 1989, the All India Judges Association and its working president filed a writ petition under Article 32 of the Constitution seeking various reliefs for members of the district judiciary focusing on uniformity in service conditions. On 13/11/1991, the said writ petition was disposed of with certain directions issued by the Supreme Court to the states and union territories to separately examine and review the pay structure. The decision of the Supreme Court rendered on 13/11/1991 is reported in All India Judges. Subsequent thereto, the central government as well as the few state governments filed review petitions before the Supreme Court. This led to another judgment delivered on 1993, reported in so-and-so. By this judgment rendered, some of the reliefs so granted in the original judgment dated so-and-so were modified and certain directions were passed. Basing upon the direction, the Union of India appointed the first National Pay Commission on 21/3/1996 under the chairmanship of Justice K.J. Sethi. The Justice Sethi Commission thereupon submitted various reports from time to time. Relevant herein is for so-and-so. From the recommendation, it is seen so-and-so. The Supreme Court, it is relevant to note that the Supreme Court in its order dated 15/7/2008 directed that the recommendations be implemented with effect from 1/4/2003, meaning thereby it had to be implemented. Now, Abhimita Sinha's judgment categorically says that if there is an inconsistency, then you kindly follow the rules, and if there is no rules, you follow the SETI Commission. Now, the division bench here holds it that the Statutory Commission has no statutory force. So, what is the basis on which I grant you that thing?
Just wondering if that order.
And this judgment of the division bench has been attained finality, isn't it? Mato?
Perhaps, madam, I was just.
So, for the state of Assam, people won't get the SETI Commission benefit.
Yes.
And I think my now order will help you, the finance department, in lowering the scales of the ministerial stuff. You can very well. Because of that bar, what was there? There was a bar. Because of that, you could not come down.
Yes.
Today, the National Judicial Commission, we are having the second Judicial Commission. This is all India cases where it is going on. It's all based upon SETI Commission.
Yes.
The very edifice, the very rock of edifice has been unsettled in for state of Assam.
I was just wondering, madam, that division bench's judgment, it might be per incurium, my lord. I'm not sure.
Oh, it has been approved. I'm bound. I can't say it to be per incurium. isn't it?
Of course.
I am bound as per the judicial discipline. Isn't it, Mr. Dhawal?
Abhinit Sinha was on marking pattern. Basic dispute was with marking pattern. Here also in Nazrul Islam Law School, basic dispute is with marking pattern. But then again, my lord, at paragraph 48, it says, my lord, no statutory force. All of a sudden it comes. I am also wondering how come this. my
Then
lord,
because if you have the statutory force, there cannot be a one-time measure
Yes,
which becomes recurring for last 23 years.
yes.
Supreme Court was clear, my lord, it is both on the judicial as well as the administrative side that the Shetty Commission's recommendations have been taken.
No, not only that. If you see this thing, I'll show you how. How the SETI Commission's recommendation were accepted on the administrative side is also clear from Assam, from Guwahati. The Guwahati High Court on the administrative side also had accepted the SETI Commissions.
Even in the affidavit filed by the finance department, that plea has been taken, my lord. That in terms of the recommendations of the city commission, my lord,
So now you don't need to follow.
at that point of time. No, my
Don't
lord,
follow.
no, now-
It has no
now-
statutory backing.
That's true. Now we may not follow, but once, my lord, that pay scale, pay structure has been, my lord, culled out and incorporated in the ROP rules.
Cannot come.
My lord, perhaps it may not come down.
No. For that, for them to get it, it becomes very difficult.
For them, it is difficult. One thing, he has been able to bring home the fact that, my lord, the industrial tribunals and they are in par with judicial institution, as has been held, my lord, in the apex court decision, which has been relied by him, as well as that Gujarat High Court decision. No dispute, no quarrel. But then there, my lord, the difficulty was with regard to SETI Commission. Now that SETI Commission has been held to be, because his.
Now, because of SETI Commission, they were getting the benefit.
Yes,
They are making the
yes.
case.
The entire-
That because of SETI Commission, they should also be given the same benefits which are given to the others.
In fact, this
The
is
SETI
the,
Commission does not have any force of law or has no value.
this is the basic foundation in the writ petition.
Another leg of the were, my lord, that the stenographer is getting more than that of the registrar. The grade
Where?
in the industrial tribunals. My lord, the grade fee of the stenographer, my lord, is 13,300, whereas that of the registrar is 12,700 in the same cases, and pay back. That was another.
So you want to equate the register with whom?
With the Sedistadar, who is the chief administrative officer of the district judiciary.
But those are different type of selection.
But in any case, my lord. those was-
2018-19 SCC. That case.
Therefore, we have taken a pleaded stand here that the post of, my lord, the chief administrative officer, Saristadar in industrial tribunal, that is a direct recruitment post. Whereas the post of chief administrative officer, in, my lord, in the district judiciary, my lord, it is a promotional post. Then this is one distinction so far as recruitment is concerned. The nature of duties will come, my lord. And then, my lord, the nature of responsibilities. Then
And
what,
they don't belong to the judicial department.
my lord?
They don't belong to the judicial department. They belong to the labor department.
Yes, as per the ROP, my lord, that fragmentation has been
No SETI
distinguished.
Commission.
Because ROP lordship may not like to touch the ROP, my lord. This-
No, I'm not going to touch.
Yes.
I'm going to dismiss his petition. Why should I touch?
No, my lord, since he will be inviting my lord's attention. to-
No, on the very edifice is SETI Commission, and SETI Commission is out because of the division bench judgment.
The Gujarat High Court judgment was also there in my favor, my lord.
But
however,
I'm not bound by
Yes.
Gujarat, but I'm bound by the division bench.
No dispute. my lord. The two institutions have been brought at par, my lord.
Huh?
Gujarat High Court decision, basically two institutions have been brought at par, my lord. The district judiciaries and the, my lord, industrial tribunal labor court, taking a cue, my lord, from section 10 of the Industrial Dispute Act. This is the basis premises of the Gujarat High Court decision.
The Maharashtra case, it has held that it is a court. In the Maharashtra. case,
Yes,
given
yes,
the-
there is no dispute, my lord, no quarrel to that. But here we are
It discharges.
on a issue, my lord, with regard to pay structure, basically pay parity. That is the issue.
Why? My contention was on, since it is a judicial institution, though it may be under the labor department, charges judicial functions and has been held to be a court. So therefore, my Shetty Commission, but now with the division bench judgment, that's lordship has come.
No, show me, see the judgment of 2018-19 SSC.
Fine.
Where the recruitment is made differently.
Fine.
Then how can you apply the same pay scale? That is one of the proposition. And apart from the division bench SETI commission, we'll make it as his submission only. Mr. H.K. Das submission. That because of that SETI commission is not binding. We'll say that. I will say that. Because that was your submission before that division bench
The
also.
given facts of the case.
No, it's
Not
over.
there.
No, here
In the-
also.
In the given facts. of
But what do you say about that observation?
Paragraph 48 has all of
Paragraph
that sudden
48
minor
categorically
fall-
says that it had to fix criteria for selecting
But
one.
that
Recommendation of the act to be considered as statutory. So,
facts of the case.
no. So are you saying that SETI commission, if it is comes for recruitment, you don't follow? It is not statutory. No. No, Amit Sinha, forget about that. But no, you see, after 57 comes 59. 59.
I have seen
Because the court after 57, 54 onwards, the court takes up various decisions and then comes to a finding in 59 that this is the proposition of law which settled.
My lord, in fact, Amit Sinha, I placed in that matter before your lordship. And 57, I relied on 57 and 69 of Amit Sinha.
What does it say?
May I just read, my lord? Likewise, in Mohinder Kumar versus High Court of MP so-and-so, the challenge was the procedure adopted by the High Court of Madhya Pradesh for recruitment of district judge entry level while discussing para 10.97 of the SETI Commission's report. The three-judge bench, speaking through FM Ibrahim Khalifullah Judge so-and-so clarified as under. Para 71 was quoted, you know. Subpara 1 to 5 of para 10.97 of the SETI Commission report have been set out to show how, while holding a written examination and a viva voce examination, prescription of marks and other aspects are to be followed. In fact, those subparagraphs contained in para 10.97 of SETI Commission report can at best be stated to be a guideline, which any High Court should keep in mind while resorting to selection for filling up the post in higher judicial service. In this context, at para 28 of All India Judges Association, this court, while prescribing the extent to which directment to the higher judicial service for the post of higher judicial service for the district judge can be made, also said that the appropriate rules should be framed by the High Court at the earliest possible time. Therefore, once the rule come into place, it will have to be held that what all that can be expected of the High Court would be to follow the said rules. We have in this judgment held that by virtue of Rule 7 and para 9 Roman 4, the first respondent High Court had every authority to prescribe the procedure while making the selection to the post of higher judicial service, and that such procedure followed was also rational. Now, para 69, thereafter, in the above paragraph, the court specifically noted that the SETI Commission's recommendation can at best be considered a guideline, and the High Court is vested with the required power to evolve its own procedure for selection of judicial officers. We must reiterate that a reference was also made at para 28 of All India Judges Association.
No, Mr. Counsel,
Which-
Mr. Das,
Sorry, I'm sorry.
following a procedure that look here, we are going to have 10 marks for this, 50 marks for this, Viva was say 20 marks, 40 marks. High Court can very well do it. But when it is given out there, that which will be the feeder category, Does it say at paragraph number 57 about that?
I'll just read, my lord, because
No.
I have also forgot. Which provided for the High Court to frame appropriate rules. Moreover, the SETI Commission itself mentioned that the recommendation was subject to prescription of rules by the High Court. Then para 69. The Justice SETI Commission was constituted.
No, before coming to paragraph 69, you have to also deal with paragraph 59, where the Supreme Court, after dealing with all these judgments, comes to two conclusions. If the rules, there is an inconsistency between the SETI Commission and the rules, then the rules will prevail.
In that case,
No,
there
no,
was no
wait,
rule.
wait. The
Yes.
rules will prevail. There is a basic rationale behind it. The rules have a statutory backing. It's a rule under 309, which the Constitution gives a statutory backing.
Correct.
Whereas the SETI Commission is a recommendation which is only sought to be implemented by the court.
Correct.
So when the rules comes in, the rules overshadows the SETI Commission's recommendation. Now we don't have the rules. Therefore, the second aspect comes in that if you don't have the rules, then there's no statutory backing. The orders passed by the Supreme Court would follow, meaning implements SETI Commission's recommendation would follow. This is 59. Now read 69.
The Justice Safety Commission was constituted to bring about uniformity in service conditions of judicial officers. The recommendations made by the Commission are in the nature of guidelines, and those will have to be seen in the context of rule governing recruitment of judicial officers. By virtue of decision in All India Judges Association, it cannot be said that adequate elbow room was not available to prescribe qualifying marks in the interview segment to ensure the selection of the best possible person. Therefore, the prescription of minimum mark in the rules is not found to be in contravention of the judgment of the All India Judgment Association so and so.
So therefore,
in that case,
therefore,
Safety Commission
when,
recommended-
just for example, let's take the example of the stenographer. You have fixed, the High Court has fixed particular thing that, okay, we will first hold an examination where everybody has to get 30 marks. This is not required that because SETI Commission doesn't say anything about those things, how much marks one is to get. After getting these 30 marks, those people who are qualified, then we'll have an interview. After this interview, we will look into again another set of interview. When this particular person gets this much, then we bring him. This is the procedure which the High Court can evolve.
That with all due respect, the division bench interfered not only on that count, there are other grounds also.
No, we have to take note of this because this is the basis,
The honorable-
you see,
I'm sorry.
the entire basis of the single judge's judgment was on SETI Commission.
Correct.
The division bench went into another aspect as regards the non-challenging of a resolution is another aspect of the matter. But a more pertinent thing is number 4, wherein it says that SETI Commission does not have a statutory backing. And rightly so.
And
Rightly so.
It's
The
not
SETI
statutory.
Commission,
It's
the division
absolutely
bench,
recommended.
right, the SETI Commission doesn't have a statutory backing. It doesn't have. But what it has the backing is that there was a direction passed that from 1/4/2013.
Look, I have reservation with regard to directions of the Supreme Court in All India Judges because there was no specific direction. If your lordships kindly consider, we are
You have
discussing the-
reservation is okay, but the thing is on 1/4, the Supreme Court direct that as you have not made those rules till now, many of the cases,
yes.
so you are now required to frame rules.
Correct.
Because the SETI Commission has given certain directions, recommendations. Following these recommendations, you frame rules. So till the rules are not framed, you are going to follow this. Assam is a state where the rules have not been framed. So under such circumstances, without the rules being framed, SETI Commission will be there in view of that order passed, wherein it says.
Lordship is correct. In that event, the situation of dearth of the stenographer grade 2 also came into place. Because that is the main reason why we had to take this one-time measure this time also in 2024.
For 22 years. For 22 years.
Maybe.
No, for 22
Correct.
years, every year there was a one-time measure.
It started from 2018, I think, so
No.
far as I remember,
No,
subject to correction.
Earlier, the first decision was taken in 2002.
13.
2002. Initially. SETI Commission's recommendation
whatever
came
may be,
in 1/4
but-
1993 or
But
earlier.
whatever it may be,
2003.
but the whole, this decision was because of that fact.
So
That-
therefore, the question is, if the SETI Commission does not have any statutory backing and there is no rules, can these petitioners
Lordship,
hearing
as-
get
my lord,
any benefit?
My humble prayer, Lordship will kindly appreciate the direction of the Honorable Supreme Court in All India Judges Association case also. Because it was not specific to the issue. It was a direction that, yes, till the rules are framed, I just forgot the exact wordings, that the SETI Commission recommendation has to be followed. But it was not very specific. And Abhijit Sinha also, that's why in
That is why in Abhijit Sinha it has been mentioned at paragraph 59.
59 says if there is no rule and
Then SETI Commission.
then
Then
SETI
you follow
Commission-
1/4/2013,
Huh.
2003.
Then in para 69 also said that 69 and 57 it has been said that there is elbow room for the High Court to prescribe the procedure.
Procedure is different. Procedure is different from, you see, today the finance is the question here. They are asking the pay.
Here the issue is totally different.
No. Here they are asking for pay on the basis
Pay
of
parity.
pay parity on the basis of SETI Commission.
Huh.
Here you don't have the High Court having any elbow here because the pay parity, the payment has to be made by the state.
Correct. man.
Now, when the High Court holds, the SETI Commission is just recommendatory.
I have some reservation regarding application of that thing in his case.
No,
As an
obviously,
officer
this
of the
has no
court, man.
statutory value.
As an officer of the court. man.
No, whatever may be, but it has categorically says that it is a it doesn't have a year.
Statutory
Cannot be
value-
construed as statutory.
Statutory
So
value is
therefore,
not settled.
so therefore, why the state should be burdened with the pay parity?
Here to they have a rule. ROP rule is there. In
ROP,
the present case,
no, you see, the ROP, if we follow the ROP rule, forget about the SETI Commission, they are out.
that's a different.
No, Mr.
I'm sorry.
You see,
I'm sorry.
ROP rule is there, where they have been put in the labor department,
Exactly.
whereas the other people have been put in the judicial department.
Seriously, that.
They say that in view of the SETI Commission's recommendation, they should be brought also within the same pay parity which is being given to the judicial department. This is his case.
SETI Commissioner recommendation to court, eh?
In fact, my lord, while going through Abhijit Sinha, I have found, my lord, the apex court has also taken into consideration the judgment in, my lord, Mohinder Kumar, my lord, at paragraph 38 of Abhijit Sinha, lordship will find. There it says, my lord, in Mohinder Kumar, Supreme Court makes an observation, my lord, in the above paragraph, this court specifically noted that the SETI Commission recommendations can at best be considered a guideline, and that the High Court is vested with the required power to evolve its own procedure for selection of judicial officers.
No, understood. The procedure for selection is different.
Exactly. But
to have a feeder post is different.
yes, my lord, what I want to bring home is the fact that, my lord, apart from Abhijit Sinha, prior there to, my lord, in 2013, my lord, in the case of Mohinder Kumar, Apex Court had the occasion to make a, my lord, observation to the effect that SETI Commission recommendation can at best be considered as guideline. So if it is a guideline, naturally it doesn't attain any statutory character. This is my submission. That is, my lord,
Well,
there.
this is true.
Yes.
There's no quarrel. The SETI Commission has no problem. It doesn't have a statutory backing. And if there is the rules, so therefore, as of now, we have the ROP rules, whereby you have put them in the labor department.
Yes.
So therefore, the SETI Commission's recommendation would have no value.
No value. And unless and until he challenges the ROP, my lord.
ROP challenge, you do it.
We cannot touch.
That
I am unable to find the specific recommendation made with regard to the registrar of industrial tribunal by the SETI Commission. If my senior friend, because the OM which has been issued by the government of Assam, it is with regard to giving one advance increment. Subject to correction, Miller.
No, they have
No,
brought
they are
an,
saying that there is a recommendation of the SETI Commission.
yes, they have brought it with. Where is
Yes.
that?
Come to paragraph for us, Dada.
Where is that, SETI Commission's?
Page. No, where is?
Registrar is not mentioned.
Then, Milord, there is no specific recommendation. I remember, Milord. There was no specific recommendation with regard to registered industrial tribunal that they have to be made parity with the judicial, sorry, Milord, the district judiciary. One document which I came across is a OM issued by the government of Assam, which provides that there has to be one increment has to be given, page 70. This is with regard to one advance increment.
Page 70 and page 72.
This is not regarding the parity. To grant one increment in the existing pay to the shareholders, to scale to the holders of the following post.
Page 70 is followed by page 72. It says it covers industrial tribunal or labor courts.
Where, page?
Page 72.
Exactly. So that's why, that's what I got confused that where is the recommendation? We are discussing so many things. Because page 70 was issued by the government of Assam in implementation of the recommendation of the SETI Commission. This is page 72 is also with regard to one advance increment. It doesn't say about pay parity. Why not? No, by this, you see the benefit of one increment to the staff, so and so.
Of my learned friend, man. If the staff of the labor court and industrial tribunal are given this benefit, the staff would also include the registry.
No, to the extent of one advance increment. Lordship, perhaps we'll have to go with the intention of the state as well as the order at page 70. It doesn't say. And that's why the state has put up an opinion at page 91.
Page 68.
It is the Supreme Court's order, madam. 1/4/2000. Commission's recommendation, madam, at page 77 has been implemented right on notification of 30th July 2012.
Yes, where is that?
Page 77, madam, the second line. In pursuance of the order dated so-and-so of the Honorable Supreme Court, WPC number so-and-so, in connection with Justice Commission's recommendation for the non-judicial staff of subordinate courts of Assam and as approved by the cabinet so-and-so. These are the financial benefits to them. If
Non-judicial staff of the subordinate courts in Assam, with effect. Benefit recommended in the pre-revised pay structure shall be given into effect in the pre-revised scale of pay from Iman to Iman, and thereafter in the corresponding pay band and grade pay so and so.
Now, if my lord comes to page 79, this continues, my lord.
70?
79, my lord.
Ah.
The second last paragraph, my lord, or the third last paragraph, just below the heading FTC, HTC benefits. The paragraph after the.
The aforesaid benefits shall
Yes,
be applicable to the staff of the corresponding grade and status working in various courts like MACT, family courts, industrial tribunals, so and so in Assam, which falls within the sweep of the subordinate judiciary.
And that it is a subordinate judiciary, my lord, that.
So we set aside this communication order dated 30/7/2012 in view of the division bench judgment. So this is the power being exercised under 309.
It's an order by the governor, it does not specifically, my lord, say.
Now, in pursuance to the remand and approved by the cabinet owner and in exercise of the powers conferred under proviso to 309, is pleased to extend the following benefits. So this is a power exercise. This should be a part of the rules then,
If it is proviso, my lord, then this the.
because this is done under the proviso to 309. So it's a part of the rules.
Yes.
So if it is a part of the rules, then you don't need to go into the city commission business. So you are entitled to the benefit, taking into account that you are entitled to all these things.
Is a.
Seristadar. Now, you are
I am registrar.
register should be equated with
My lord, here in the page 79, the heading number Roman 9, D, my lord, Chief Administrative Officer, Registrar of District.
okay. So you are register.
The Chief Administrative Officer of the Industrial Tribunal.
It's only in the name. But what you do is the chief executive officer.
Corresponding staff. Submission.
Chalo. Now, the state have already equated these people. The aforesaid benefit shall equally be applicable to the staff of the corresponding grade and status working in corresponding. You see the word corresponding grade and status working in various courts like MACT. So therefore, in view of this notification, which has has a statutory force, taking into account that it comes under 309, proviso to 309, then why the petitioner would not get the corresponding here would be this, isn't it? So, good case.
Corresponding, my lord, here lordship will kindly see.
Unless you show that this is not a corresponding, it is now the burden is on you.
So corresponding, that's what we have said, my lord. Lordship will kindly see, my lord, page 77 for a moment, my lord, the first paragraph. In pursuance of order dated 7/10/2009 of the Honorable Supreme Court of India WPC in connection with Justice Setty's Commission recommendation for the non-judicial staffs of subordinate courts in Assam, and as approved by the cabinet in its meeting dated so and so, and in exercise of the power conferred by the proviso to Article 309, the Governor of Assam is pleased to extend the following benefits to the non-judicial staff of the subordinate courts in Assam with effect. Lordship will kindly mark this, but non-judicial staff. The financial.
So he's a non-judicial
No,
staff.
non-judicial staff, therefore, my lord, the financial benefits recommended in the pre-revised pay structure shall be given effect to in the pre-revised pay scale from 1/4/2003 till 31/12/2005, and thereafter the corresponding pay band so and so is as revised in the state with effect from January 2006. Now, here the opening second line says, my lord, in connection with Justice Setty Commission's recommendation. The entire,
Understood. But now it has got the flavor of a statutory rule. Because this is done under 309.
this is done under 309, therefore Lordship will kindly see.
So
what
now
are
you
the-
kindly come down to page 79.
no, before
The
that,
aforesaid benefits shall equally be applicable to staff of so-and-so, corresponding grade at so-and-so, etc. in Assam, which falls within the sweep of the term subordinate judiciary.
exactly, so this is the concluding remark, but what are the benefits? Let us see the benefits, my lord. Lordship will kindly see the benefits.
Ah.
He is seeking pay parity. First one is medical allowance.
No. Now, you see, in view of this document, Mr. Nayar's endeavor shall only be now what? Nothing more than that. Because you see, first, the governor of Assam, by a 309 backing, Article 309 rule backing, recognizes them as a part of the subordinate judiciary. One.
Yes.
The only thing which Mr. Nair has to show out here as to whether the post of the registrar is corresponding to the post of the Chief Administrative Officer, Seristadar of the District Judge. Nothing more than that in view of this.
Absolutely, Lordship will just kindly come to the next paragraph. The next paragraph there too.
Yes.
Here I may draw some inference trigger. If any of the employees of subordinate courts is drawing under the ROP 2010 and or any other existing government order higher pay benefits.
No, this is as per the Supreme Court judgment. You see, if a person is otherwise you kindly come to page 60. This is exactly that direction. Kindly come to page 68.
68.
See the last paragraph. Page 68. Yes. Roman 4.
Yes, my lord.
In some of the states, based on various other pay commissions, benefits have been given to the members of the AR. These benefits, if any, in addition to the recommend. In any case, if the members of the staff so and so and higher benefits under any of the recommendation of the pay commission, they shall be permitted to avail the same. So this is as per that. Therefore, this is the same term being used out there in that paragraph, page 79.
So it is true.
So, Mr. You only endeavor is its equal. That's all, nothing more than that. Other things are already solved. City Commission is not statutory as per the division bench. Not required to be followed. But they have made it followed. They cannot go back in view of that notification, which is a dangerous proposition for the state.
Judicial department, well, perhaps the judicial department will have to defend.
Huh?
No, I will be happy. I know that is on
No, you are bound by that. No, are you saying that the governor of the finance department and the governor of the social
No, no,
welfare
no.
department is different? No, I'm telling you.
No, that is not the tenor.
Then there are many judgments of the Supreme Court which says that the state should speak in one voice.
No, that is true, my lord. I'm
Then-
not that way.
To address the
That day I was getting one matter, yes. Mr. B. Gogoi was appearing, where the Health and Family Welfare Department have issued a notification of the governor saying that the Ayurvedic doctors would also be given for the purpose of pay parity will be recognized as diploma holders will be recognized as so and so. And the finance department is objecting. Finance department cannot object to notification of the governor.
We have our
Or,
own parameters.
finance department is above anything because they have money.
Well, at the end of the day, my lord, we are required to deal with the parameters, my lord. Permutations and combinations of running the state, my lord.
different because it is headed by my letter. No, he has
So my
you have a good case now, huh?
my endeavor will be, my lord.
There is no
First-
endeavor. I think he has a case. I think you should be given. You are only registered. How many person? Only one register.
Now therefore, the High Court has sought for filling up for creation of posts of head assistant in all these establishments, MACT, Labour Court, Industry Tribunal, and that proposal has been put forward. I have annexed in my additional.
The High Court's proposal is a different thing. It happens on the administrative side. Whether it is fulfilled or not, that is another aspect.
The government of Assam's direction.
This notification of 2012 speaks of the benefits that has been mentioned herein.
No, the benefit is the scale of pay also. You kindly see this.
Therefore, let him let him raise his argument with regard to the, from this document, that the scale has to be at par, my lord.
No, his only endeavor has to be that because of the word corresponding,
Yes.
which is appearing in page 79.
Therefore, what benefits, my lord, the aforesaid benefits, kindly.
No,
see-
he says
Yes.
his only endeavor would be that the post of the registrar
Yes.
is the same functions discharged by the
Yes,
chief administrator.
yes,
That's
what-
all.
yes.
He need not even have the
That I will
problem
rely
of,
on my affidavit.
no, because he did not have the problem with going into the 2019-18 judgment also because of all these things. Only thing he is to say that the same functions are being done, nothing more than that. Ah.
143, apply to the finance department, sir.
Anyways, I think I should rise. Yes.
143, the last line, my lord.
Hmm.
It, beginning with, it may also be mentioned here.
Hmm.
That the nature and duties of registrar of industrial tribunals and labor courts and the registrar of district and civil service court are identical inasmuch as there is no other judicial, non-judicial post superior to either of the said posts of registrar and registrar in their respective establishments. And the incumbents of the said.
Page one?
92.22.
Page 143. my lord.
Okay, nature of duties of the registrar of the industrial tribunal and labor courts and the registrar of so and so are identical in as much as there is no other superior to their of the Iman and in respect to the Iman.
Function is the administrative head of the respective.
No, but what are the functions?
Functions would be to the administrative.
Where is your statement?
That I can find.
How many you are going to buy?
Already two
Well,
by.
that is the one, but
Huh?
but at page 79, my lord, to address my learned friend's, my lord, apprehensions. My lord, my learned friend was on only certain benefits have been given under this 2009 or 2012 notification. That is incorrect, my lord. At page 79, the base scale as per Shetty Commission is mentioned. Page 79, my lord. It is not only the benefits at the.
Then I've seen it.
Yes.
It
No,
is
there's no, forget about SETI commission. SETI commission, the division bench has set it for a 6. So we are not on SETI commission. We are on that order of 2012,
But that
which is the
2012
309.
On this 2012 order, my lord, the base scale is.
Yes,
I-
that
I
is,
was-
it is categorically mentioned. That is why I'm saying your only endeavor is that the post of the registrar discharges same functions with the chief executive. That thing more than that. If you just do that, it's over.
My lord, here in my affidavit at page 143, 144, my lord, that is the thing which.
You say that the nature of the duties so and so are identical. So do you want that this court should go there and make a
No, my
field visit that
No.
what this head assistant of the AR do and the AR?
My lord,
No, if you want, I can go there.
my lord,
Huh?
not at-
There?
not at all, my lord.
It is for you to give more details.
I'll find one addition that.
No, he should get. He has tried his luck.
I will try to defend my lord.
Huh?
I will try to defend my lord.
No, define it. You should have mentioned it. I would have allowed your petition today itself. Why do you give the finance more options?
But I'll draw a comparative.
No,
table, sir.
huh?
I'll make a comparative
Oh,
table.
no, so therefore I will reduce the further objection he may raise by passing some order now. So, heard Mr. P.D. Nair, the learned counsel appearing on behalf of the petitioner, Mr. R. Babudari, the learned counsel appearing on behalf of the finance department, and H.K. Das, the learned counsel who appears on behalf of the Guwahati High Court. The dispute in the instant proceedings pertains to the non-granting of the non-granting of pay parity to the petitioner who is rendering service as a registrar in the MSCT,
Industrial tribunals.
in the industrial tribunal, with that of the chief executive officer oblique Seristadar in the office of the district and session judge. Full stop. Though initially the petitioner have claimed on the basis of the SETI Commission's recommendation, but taking into account the judgment of the division bench of this court in the case of Guwahati High Court, versus Nozrul Islam Loskur, dated 22/9/2025, wherein the learned division bench has opined that the recommendation of the SETI Commission cannot be considered or be construed as statutory. The question therefore devolves upon as to whether the petitioner herein would be entitled to on the basis of the SETI Commission's recommendation. Full stop. While perusing the materials on record, it is apparent, perusal of the materials on record, it is seen that pursuant to the directions passed by the learned by the Supreme Court, in the All India Judges Association and another versus the Union of India report, Union of India, dated, what is the date?
7/10/2009.
7/10/2009, comma, the Government of Assam had, in exercise of the powers under the proviso to Article 309 of the Constitution, had issued a notification dated 30/7/2012, whereby the benefits have been, whereby benefits have been extended to the non-judicial staff of the subordinate courts in Assam with effect from 1/4/2003. Full stop. It is very pertinent to mention that the benefits mentioned therein included the financial benefits recommended in the pre-revised pay structure from 1/4/2003 to 31/12/2005, and thereafter in the corresponding pay band and grade pay, as revised in the state with effect from January 2006. It is very pertinent to mention that in the said order, said notification dated 30/7/2012, the pay structure of the non-judicial staff of the subordinate courts have been duly mentioned, including that of the Chief Administrative Officer oblique the Solicitor of the District Court. It is also very pertinent to take note of that in the said notification, it has been clearly mentioned that the benefit shall equally be applicable to staff of the corresponding grade and status working in various courts like MSCT oblique Family Court oblique Industrial Tribunal oblique Labor Courts oblique Court of the Special Judge CBI, etc. in Assam, which falls within the sweep of the term subordinate judiciary. Therefore, the only question which arises in the instant proceedings is to decide as to whether the post of the registrar of the labor court can be said to be corresponding to the post of Chief Administrative Officer oblique Solicitor of the District Court, Judges Court. It is relevant to take note of that an affidavit has been filed An affidavit in reply was filed by the petitioner to the affidavit in opposition filed by the respondent number 6, wherein at paragraph number 6, the petitioner had mentioned that the nature of duties of the Register of the Industrial Tribunal and Labor Courts and the Register of the District and Session Judge Court are identical, inasmuch as there is no other non-judicial post superior to either of the said post of Register and Registrar in the respective establishments. It is also mentioned that the incumbents of the said post function as the administrative head of their respective establishment. This court inquired with Mr. P.D. Nair as regards the nature of these duties of the Register of the Industrial Tribunal and Labor Courts vis-a-vis that of the Registrar of the District and Session Judges Court. The learned counsel, appearing on behalf of the petitioner, submitted that he would file an affidavit, additional affidavit, by drawing a comparison between the nature of duties and functions performed by the Registrar of the Industrial Tribunal / Labor Court with that of the Registrar / Head Assistant of the Head Registrar / Chief Executive Officer, Chief Administrative Officer of the District and Session Judges Court. Full stop. The said affidavit be filed within, taking into account that the matter has been substantially heard, list this matter again on 12th of February 2026 at the top of the list. At the top of the list. In the meantime, the affidavit be filed on or before 4th of February 2026. Liberty given to the Finance Department as well as the respondents to file any reply on or before 11th. You just bring that. We'll allow your petition. Oh, your matter. Yes, we'll take it. Motion to adjourn. Yes, what is your case?
I'm challenging the automatic case 17, my lord. I'm at serial number 4. Limon Kusumatari.
You've been transferred
Yes, ma'am.
from
From
RB Anglong to?
including Kavi Anglong, my lord. But what happened, my lord, I am an employee of the Treasury Department. I have been transferred to my lord, Labor and Employment Department. My lord, petition list are maintained separately, my lord.
Where is that?
My lord, page 17, my lord, serial number 4. Designation Senior Treasury Accountant, Depot Treasury, and temporarily addressed Employment Officer, District Employment Exchange, Depot.
What is your name?
Limon Kusumatari. Serial number 4.
You say that it cannot be done.
Right. Because I am an employee of the Finance Department, my lord. I cannot be transferred to my lord, Labor Department, my lord.
You are working as
Because I am
grade
working-
3.
My lord, I am working as my lord, Senior Treasury Accountant.
Well, what is this, Mr. Papudari?
Yes. Also employee of the combined cadre, my lord. Recently, my lord, all the cadre has been combined and the recruitment has been made combinedly, my lord. But my appointment was made.
Oh, no. Then you don't have a case. If the cadre has been combined, you don't have a case.
My lord, since earlier, my lord, they were appointed, they had been combined, my lord. Their relation lists are maintained separately, my lord.
No, are you not now maintained in a common cadre?
No, my lord.
Your graduation list is separate.
Separate.
Still now.
Still. One more aspect, my lord. Paragraph 3 of my petition. I have stated that, my lord, against the other persons, my lord, there are some complaints. complaints of misappropriation as well as some other complaints, my lord. And they have been transferred as a measure of punishment. I have been, my lord, clubbed with their them, my lord, only to humiliate me, my lord. There is no complaint against me. And if I am transferred along with them, my lord.
No, that is no good. I am not going to go into all these things. That is not a ground, but you are putting before, it is only, the only question out here is whether the senior treasury accountant Defoe, whether you can be transferred from here to there.
Yes, ma'am.
Only question is that.
Yes, ma'am.
Here, Lordship will kindly see the appointment order. I will draw my lord's attention to the rules, my lord. Kindly see appointment order at page 15. First, let us see the facts, my lord, quickly. Bimal Kumar Basumotari, so is appointed as junior accounts assistant. Junior accounts assistant and posted in Bokazan sub-treasury against the newly created post of junior accounts assistant. The expenses so he comes under the new pension. So this is his appointment order. Appointment, it is dated, my lord, 17th of May 2008. Here, the service conditions will be governed by the Assam Treasury Establishment Rules 1993. The feeder post is, my lord, the junior accounts assistant. Then the person is promoted to senior accounts assistant, finally treasury officer. Then, my lord, if one is fortunate, he gets to the higher level. It is just like, my lord, a lower rank police officer attains the status of a, my lord, superintendent of police, or he becomes a nominated APS or
No, it's
something like
okay.
that. Yeah.
No, but
Now, Lordship will kindly see, my lord, the next page, my lord. The next page.
So he's being promoted as a senior accounts officer.
Yes, promoted as senior accounts assistant. So under the Treasury Establishment Rules 1993, that is the service rules applicable on board across all the cadres, my lord, under the Treasury Establishment. And the controlling and regulating officer for each Treasury district is the district commissioner. So therefore, the district commissioner has issued this transfer order. Now, so far as the page 2 is concerned, my lord.
No, the question is,
yes,
can he be sent to the employment exchange?
Absolutely, because in the employment exchange also, there may be a post of, my lord, senior accounts assistant. He is a person of accounts. He is appointed in the service of accounts. Junior accounts assistant, senior accounts assistant, treasury officer, so on and so forth. If in a particular establishment, there is a post of senior accounts assistant, why not transfer him? Why is the prohibition under the rules? Let him show that. Why is the prohibition under the rules?
Which rules?
My lord, only submission before working. That, my lord, both the departments are completely different departments. Finance department and the labor department. And the seniority list, education lists are maintained differently, my lord. They cannot be clubbed together, my lord. That is one aspect, my lord.
No, let us see your appointment rules. Which are the rules?
The appointment order, my lord,
This is being done by the deputy commissioner.
yes, ma'am.
It is done by the
It is the deputy commissioner.
deputy commissioner.
Is the, my lord, district head of all the departments, my lord.
So he has not, all the departments, he is the district head.
Yes, ma'am.
Now the question is, whether you belong to the finance department?
Yes, ma'am.
Yes.
I belong to the finance department.
He
the labor
is
department.
under the Treasury Establishment Rules, my lord, 1990. I do not have the rules as of now.
Also civil rules conduct.
Treasury Establishment Rules, 1993.
We'll do one thing, we'll take up the matter too.
Yes.
You get the rules. Then I'll pass. Treasury Establishment Rules.
Assam Treasury Establishment Rules, 1993. Huh? No, 1993. 1993.
So you say that it is the deputy commissioner who does it.
Under the rules, the deputy commissioner is the controlling authority of the Treasury establishment in his district. So the appointment, everything is made by the office of the district commissioner. Therefore, Lordship will find, my lord, his appointment order at page 15 that the
But
appointed.
can he tomorrow,
Yes.
I'm asking, a treasury person who is appointed under these set of rules,
Yes.
can he be brought to another department of
Yes. Yes. He
how?
can. Well, because it relates to my lord, the financial aspect of the post is concerned. It depends on the financial aspect of the court. Meaning thereby, my lord, that he is a person of accounts, junior accounts assistant, senior accounts assistant. He might have been posted in the treasury office, but there are perimeter posts available in other departments, other establishment within the same district. So therefore, this transfer can be made. It is as simple as that. He will have to show that the post of senior accounts assistant in my lord employment actions DFO is altogether a different post than the post of senior accountant assistant in treasury establishment in DFO. That distinction has to be brought in by him. So he is the dominantity. Where is the prima facie case? Because the
And a person who is appointed in the employment officer,
yeah.
office of the employment officer is under the employment exchange, under labor department.
Yes, ma'am.
No, labor, he works, no, not under the labor, he still, the controlling authority and the regulating authority will still be the district commissioner.
Therefore,
Yes, that's what I.
that is my question now.
Yes, so therefore he will have to show with convincing materials that.
Okay, by 2 o'clock we take, you just obtain one instruction as to whether separate gradation list is maintained. Now, what happens if tomorrow?
Because this has to come from the district Karbi Anglong commissioner.
Mr. Borpudari, normally I don't stay a transfer order, but if it is a case that it is not possible for the one person from this post to that post be transferred, then obviously I'll stay. That is the only ground. Because he cannot have any, an employee of the state cannot say that, okay, I have some problem from becoming from treasury to employment. I can't, he cannot say anything. That's absolutely within the administrative exigence.
Yes.
He cannot, because he's still in DFU.
Yes.
I would have heard that he would have put in some other place, it's a different thing.
And Lordship will, at the end of the day, will interfere when there is, my lord, absolutely.
Interfere is different.
Yeah.
Stay is different.
So therefore, my lord, stay.
I don't grant the stay so easily in these matters.
Stay can be granted only if he satisfy your lordship.
So 2 o'clock.
With malice.
No, 2 o'clock.
Yes.
Because I have to rise earlier. Only one matter, this matter will take it. Because you just find out one thing, whether they maintain a separate graduation. What happens to his tomorrow about his seniority? Just
Yes.
find out.
Yes, absolutely. But it is a old rules, not readily available. In the internet also, it is not available, my lord. I have summoned for that rules. But the thing remains, my lord, I have taken instructions from my department. It is absolutely within the purview of the district commissioner. Because under the rules, he is the, my lord, controlling and regulating authority. Now, so far as, my lord, maintaining the gradation list, etc.
They fall within the ministerial stuff.
They fall within the ministerial stuff, but they have a separate service rules,
That's
my
the
lord.
ministerial stuff rules.
Yes. Keep alert, no? Itu kok dia? Mana my kok dia itu kok dia?
District Assam Directorate Establishment Ministerial Service Rules. Here you see, if you see the Assam Directorate Establishment Ministerial Service Rules, 1973. They won't come under the Assam Directorate Establishment Ministerial Service Rules.
No, no, my lord, there are separate rules, my lord, that I
So
remember. my lord.
then the deputy commissioner, how does he appoint him? Because you
Everything
see, if
there
it is the directorate establishment, because if you see these service rules, the director of accounts
My lord,
is the head of the department.
yes, my lord.
For,
Director of
wherein it
Accounts
is
and
the Secretary
Treasuries.
Finance, E. Whereas for labor is the labor commissioner.
But the district commissioner is also the district treasury officer.
Hmm?
District commissioner is also the district treasury officer. madam. In that capacity, perhaps he can.
You see, Director of Employment and Craftsman Training
My lord,
is the head of the department for the purpose of,
yes,
is the appointing authority under the Assam Directorate Establishment Ministerial Service Rules.
yes,
Okay, so here there will be there. Now he is appointed as a junior accounts assistant.
yes.
How does he fall within the ambit of the deputy commissioner?
Because, my lord, under that 1993 rules, the scheme is such, my lord, that the selection and appointment is done by the district commissioner, deputy commissioner. Selection and appointment is done by the district commissioner, and so long, my lord, he is in that cadre, my lord, within the establishment of the district commissioner, he would continue to be, his services would continue to be governed and regulated, my lord, by the office of the district commissioner.
So if that be so,
Yes,
then under the employment officer, district employment exchange, how is the deputy commissioner the appointing authority?
Under education, he has the authority.
no,
Where is
he-
that?
and
Yes,
my colleague, colleague appearing for the district commissioner has got some instructions, my lord.
What is it?
Yes, my lord. Yes, kindly say.
Lordship, just before some time, I had a talk with the Deputy Commissioner of Karbi Anglong, Lordship, and he informed me that, Lordship, after this appointment, this thing to transfer order, there is one more order dated 21/1/2026, but this is the same ditto copy of this order. But what he telephonically informed me that he is only being, this petitioner only being temporarily attached to the office of the employment officer, employment exchange, only been temporarily attached, and all the pay will be debitable from the earlier source, Lordship. I mean, the accounts officer, from the office of the account officer default, Lordship. So in that regard, Lordship, the question of this pay, great this thing, great pay, so
No, that is not there, but he means you are going to keep him there.
we want to keep him for some time in this office, but his pay will be from his earlier source, earlier place, Lordship.
So that means you are taking some action on punitive basis.
Yes.
Something has to be done.
That will be. What am I feeling it time?
This is the treasury rules. So these are treasury rules.
With it, 9th of September. Within the same department, he can transfer. He has been authorized. The deputy commissioner. This notification matter of 9 September 2021. It empowers the deputy commissioner to transfer any staff matter within the same department, not to other department.
Now, this is excluding the 6 scheduled districts.
Yes.
We are concerned with Karbi Anglong is a six schedule district, so therefore this notification would not apply.
In the event, my lord, in 60, my lord, he has the project transfer. If it is not applied, because this is the only notification that is provided by the deputy commissioner of authorized.
One more thing, Lordship, in the order there, along with him, there are another 4 persons, and there is a transfer slash attachment. And Deputy Commissioner, while talking with me, was putting stress on this attachment thing. So question of transfer, because the order is of total 5 persons. Along with him, and the order is of total 5 persons. And he is 1 person along in the list. And what the order reflects, transfer slash attachment. And Deputy Commissioner, while talking to me, has stressed upon the word attachment, not transfer. So this thing, that whether actually it is actually transfer or not, that Lordship, I'm not 100% distinct sure today, as the matter has come up for the first time. I think I appeared for the first time today. But what he has stressed upon is the word attachment, Lordship. That is also done very temporarily, and nothing is going to be changed in regard to his pay distinct.
I have stated in paragraph 3 of my petition why the other persons have been transferred. The other persons, my lord, why they have been transferred, I have stated in paragraph 3, my lord.
But you have been only temporarily attached,
Yes, ma'am.
not transferred.
But as a cumulative vision, ma'am, I've said, my statement, my submission is that, myself, that as there are allegations against the other persons who has been transferred along with me, there are allegations against them. Some, video clips were, made viral, taking bribe from the public, because of that, those persons were transferred.
No, you are temporarily attached, so we do one thing, not a.
Let us file the affidavit. Let me file the affidavit.
Let them put in on affidavit what they want to say. You go, in the meantime, you do that, but nothing is going to change and nothing is going to happen. You are only doing there. It's not any other instance out there. Let us, we'll set aside this thing within a week's time. Issue notice making it returnable on 2nd of February 2026. Mr. Arbor Buzari accepts notice on behalf of the respondent number 1,
My lord, 1, 2, and 4, my lord.
1, 2, and 4.
My lord.
And Mr. C.K.S. Borua.
For respondent number 3.
For respondent number 3 and 5.
3 and 5, Lordship.
3 and 5.
3 and 5.
The petition, extra copies of the writ petition be furnished upon the learned counsels during the course of the day. The petitioner herein is aggrieved by the, what is this, 19/1/2005?
That is that order.
19/1/2025. 19/1/2025.
25. You're 26.
Typological error.
Typographical error, but it should have been 26.
If Lordship is pleased to peruse page 17, 1/7, that is the imperial order.
In the last.
In the upper portion, Lordship will find it 19/1/2025.
26.
Yes, but in the digital signature, Lordship will find it at 21/26.
I've challenged the order dated 19/1/2025, bracketed the sick, digitally signed on 21/2026, whereby the petitioner who is rendering service as the senior treasury accountant DIFU Treasury have been temporarily attached to the office of the employment officer, District Employment Exchange DIFU. Mr. C.K.S. Borua, the learned counsel appearing on behalf of the District Commissioner, Karbi Anglong, submitted that upon his he has been verbally instructed to apprise this court that the petitioner have been only temporarily attached, maintaining all his pay scale and seniority in the office of the Treasury.
Yes.
Office DIFU.
Yes.
And as such, the petitioner should not have any grievances. Pusto. Mr. I. Saikia, the learned counsel appearing on behalf of the petitioner, however, submits that the petitioner, that there are allegations against the other persons who have been temporarily attached in the impugned order dated 21/2026, except the petitioner. But the petitioner, for reasons best known, have been temporarily attached to the office of the employment of officer, District Employment Exchange, DIFU. In addition to that, Mr. Saikia has also submitted that the district commissioner would not have the power to transfer, that too without taking into concurrence with the head of the Department of the Employment Office. Taking into account the above, it is the opinion of this court that as the petitioner have been only temporarily attached, keeping his status and position intact in the Treasury Office of the Treasury, this court would not like to pass any interim directions without giving an opportunity to the respondents to place their stand by filing an affidavit. So the affidavit be filed by the district commissioner, district treasury officer on or before 30/1/2026. And more particularly countering the allegations made in paragraph number 3 of the writ petition. List accordingly. On the next day, this court would attempt to dispose of the writ petition, and in the circumstance the writ petition cannot be disposed of, this court would consider as to whether there is any necessity of passing any interim directions.
What has been placed in the place of the petition?
Huh?
All the 4 senior treasury office accountant minor, they have been passed, no one has been replaced.
Mr. Saikia, you have to also understand, I also understand why you want to be there in the treasury office.
Same, this is not a transfer order. I have gone again and again. The temporary attachment.
So nothing is going to.
Yes, yes.